Are you there up to that?
Yes.
Would you understand?
Your ladyship, IA number is 6385 of 2023.
It is a surviving defect.
Your lordship.
It is under defects.
Yes.
What is a surviving defect?
Defect number 5 by which it was pointed out that respondent number 1 to 5 were not added.
Defect number 5?
Defect number 5.
The surviving defect is defect number 6.
We have mentioned in para number 3 of the IA lordship.
Of IA number?
IA number 6385.
Para number?
3.
What is the date of death? Yes.
Your ladyship, it is the IA for adding parties.
What is the date of death? He was never substituted before the learned court. What is the date of death?
The IA that she's pressing, this is for adding parties, the respondent numbers 1
Because-
to 5, which who have not been added as parties, they were not made parties. They were parties in the decree.
There were parties in the
They were
decree.
parties in the decree.
Show me the decree.
Due to inadvertence, that was not added.
Show me the decree, please. Page number?
Your ladyship, page number 63.
The appellate court decree. A trial court decree. Whose respond number?
1 to 5.
He was defendant number? 1A to 1E, his defendant number?
1A to 1E is defendant number, the respondents here in W.
Yes.
1 to 5.
1A to 1E or 1 to 5? And they were defendant numbers?
They were defendant numbers 1 to 5. Vansh Mia, Mohammad Asif, Musammad Sajari, Khatlu, Samud.
And you have made defendant number?
We have made them defendant numbers 1A,
1A, 1B, 1C, 1D, and 1E.
One A, Ahmed Hussain. Sorry,
1A,
it's Mohammad Samim. You see, you have 1A, Ahmed Hussain. Who is Ahmed Hussain?
They are the appellates. They are the
Ahmed
appellates
Hussain
in
is the appellant.
Yes, he is the main appellant in the second appeal. They are already on record. And due to inadvertence, 1, 2, 3, 4, 5, their names could not be added. That was the defect that was pointed out.
It is very much there in your memo of appeal.
That was the defect that was pointed out. It's not there.
respondent number 1 to 5 of CC of decree under appeal has not been made party in the memo. So,
1 to 5
decree under appeal will be the appellate decree.
the appellate decree.
Where is the appellate decree? This is the trial court decree.
This is the decree in appeal, Bishop 62. The trial court decree is page number 44.
Decree in original suit, right?
Yes.
Trial court decrees. There is no running pagination of these judgments. So they have been put as enclosure, no?
They have been put as enclosures, page number 63 to 68. They are the names of the parties. They are the memo of names of the parties.
63 to 68. This is the appellate court decree.
Appellate. The confusion is because there are too many parties. So
Yes, certainly. But you see, we have to be very careful
Yes.
with regard to party position unless it is very clear.
Definitely.
Civil title appeal at page number 65 starts from 2E.
From 2E. Yes.
Yes.
Mr. Jharkhand.
Right?
Yes.
And the appellants are the plaintiffs only.
Appellants are
Before the appellate court, show me the name of this respondent number 1 to 5.
Respondent number 1 to 5. Karamat Mia Jarina Khatun, this one.
Karmat 1 to 5. Respondent number 1 to 5.
Leadership, it is from 6, page number 65, from serial number 6 onwards. Down, verses. Karamat Mia Jarina Khatun,
Yes.
6 onwards.
Karmat Jarina Khatun.
Kamuddin Liaquat Hussain.
What about
The previous ones.
yes, respondent number 1 to 5 in the appellate court decree?
1 to 5.
The name of the respondents in the appellate court decree appears from serial number 6.
Yes.
Yes. Where is the respondent number 1 to 5 in the
Before
appellate
that.
court decree?
Before that.
Where is that?
Leadership, it is at 6 in my memo of appeal at page number 2.
No, I'm just asking you. Where is the, you see, you were the plaintiffs, you have filed your appeal was dismissed, second appeal, your second appeal was
Second.
also dismissed. Fair
Uh,
enough.
second.
But in the memo of appeal, the party position starts from respondent number 6.
Yes.
Where is respondent number 1 to 5?
Leadership 1 to 5 are the plaintiff appellants.
1 to 5, no. They are the defendants because all the plaintiffs are the appellants.
They are the defendants. So they are, leadership, they are here. They are on page number 2, may we see, of my memo of appeal.
No, I'm just talking about this decree. You see, you were the plaintiffs,
We were the plaintiffs.
you lost,
We lost.
you filed your appeal.
We were the appellants.
Who were the defendants number 1 to 5 in the
Defendant
original
number
suit?
1 to 5 in the original suit.
Yes.
Karamat Mia. Leadership from Karamat Mia versus at page number 3 of my memo of appeal.
Yes.
Karamat Mia Jarina Khatun.
You have, you see, defendant number 1 to 5. Jarina Khatun, right?
Yes.
Kutu
before that-
Putin, Karmat Mia, Jarina Khatun. They have been numbered as respondent number 6.
6. Respondent numbers 6 onwards.
They ought to have been respondent number
1.
1.
Respondent
Isn't
number
it?
one. Yes.
Is there an error?
Yes, there's an error. They ought to have been respondent number 1. But leadership, I think it is because these the previous ones from 2E to 6H.
Yes.
We'll have to cross check this.
You have to
I will
cross check
cross-check.
it. Please
I will
do
cross-check.
it because this decree is required to be rectified.
Yes, I will cross check.
So you do it right away. I'm posting it tomorrow. We have seen the records. You just tell us. You just give a comparative chart, right, as to who are placed at what position, and then we will. If it is just a number of the sequence etc., then it has to be edited accordingly.
Accordingly, a petition will have to be filed.
This record will go back to the court. We'll send this certified copy to the court
I will check.
for rectification.
I will just check.
Post tomorrow. Appellant present, post tomorrow.
Item 4, second appeal 32 of 2023.
Vijay Shankar Jha. Who's that? Virendra. Pass over to me. Right. Are you there for the petition appellant? Nobody appears on behalf of the appellant. Rather, you taking this one. Appellant absent. Time till 31st January is granted to the appellant to remove the surviving defects by way of last indulgence. Premti nahi kari. Post on 4th of February. Post on 4th of February.
Item 5, second appeal 34 of 2023.
Lordship, there are 6 surviving defects. I'm only paying for 2 weeks time for removal of the same.
Same order. Appellant present. Premti time नहीं लिखता. By way of last indulgence किए हैं, and if the matter comes up again, then I will dismiss it on the very same day.
Item 6, second appeal 37 of 2023.
Appellant present, same.
Item 7, second appeal 38 of 2023.
Serial number 7.
7 appellant present same order. आप सर्टिफाइड कॉपी और डिप्टी भी नहीं फाइल की,
Yes, we will file. We got that.
कोर्ट फीस भी नहीं फाइल की.
We will do that.
Just imagine 2023.
Yes, we will do that.
appearance
You check the defects. अगला दिन में डिफेक्ट रहेगा, हम कोई प्रेमली टाइम नहीं करेंगे. I will just simply dismiss the case.
Yes.
Item 8, second appeal 40 of 2023.
In this matter, I am taking the reduction to removal of the records.
आपका भी कोर्ट फीस भी शुरू. फाइल करके क्या ही करते, कोर्ट फीस भी नहीं जमा करते. लिटिगेंट का कोर्ट फीस भी रख लेते हैं.
No,
Yes.
that's not the.
You don't take court fees at the time of filing from the litigant. Let me just understand this. कोर्ट फीस रखना तो सही बात नहीं है ना. Same order. Appellant present. With 31st January, the last indulgence, post on court.
Item 9, second appeal 41 of 2023.
Yes, defect number 1, 6, 7 and 8 are remaining conditions. Whereas 1 is the CC of the judgment of the trial court with air for rupees 10 per page. And rest 3 leadership, I'll be removing it during the day.
You have got this, received the copy?
No,
Certified
this
copy?
is only for serial number 1 leadership.
Yes.
I
Trial
will
court
be praying
judge.
for 3 weeks time.
Okay, same order. By 31st you remove it. I am telling you, I am posting it on 4th. The matter is pending.
Yes.
You must have applied for certified copy, I am sure. You get it. Since 2nd of March 23, the matter is pending.
Yes.
Same order. By way of last indulgence till 31st January. We are posting it on 4th of April.
Item 10, second appeal 48 of 2023.
Yes.
In this, there are 2 defects. One is on the certified copy of judgment and decree. We filed it, Your Lordship, on the last day. Direction was given to the office to verify it, Your Lordship.
rest of the defects?
Lordship, one is about the limitation.
I do not know. That is your problem.
Limitation application also, we filed a motion.
There are certain defects to be removed.
This you should check regarding the court fees. That has to be verified with the. We've
Court
mentioned the
fees.
court fees on
Then
the
the value
memo
of the
for
second
appeal.
appeal.
Your Lordship, you mentioned it on the memo of appeal, Your Lordship. This has to be verified and we have to file.
Appeal valued at 275. सभी चीज has to be reported. यहाँ पे तो दिया हुआ है appeal value. नहीं suit then first appeal then second. Right?
Yes.
All the three valuation have to be there, which is missing.
Correct.
Correct? So I'm just posting it on next Monday.
Yes.
The need should be right. Second appeal 48 of 2023. Counsel for the appellant undertakes to remove the surviving defects by during the course of the day. We do it by tomorrow.
Yes, Your Lordship, but if the court fees also defect on.
Court fees के लिए क्या चाहिए? What instruction do you need for court fees? Remove. By Saturday, 4 तारीख खुला हुआ है. By 4th of January. Post this case on 6th January.
Item 11, second appeal 49 of 2023.
Lordship, defects with serial 3, 4 and 5 are still surviving and I'm paying for 2 weeks time, Lordship.
Only court fees is surviving, right? Second appeal number 49 of 2023. The counsel for the appellant undertakes to remove the surviving defects by 16th of January. Prelim. If the defects are removed within time, post 120. It's a preemptive order, kindly do it.
Item 12, second appeal 201 of 2023.
What all are the defects?
The CC of judgment is the Lordship. Another few.
CC of the impugned judgment has not been filed.
Research as per the defect.
Yes. ये किसका ये कौन सा फाइल करते हैं?
That is the. We have told
It
them.
is civil appeal. So this is not a certified copy of the decree, man.
Yes.
Or decree or not?
Yes, we have told the client.
Sorry.
We have told the client, Lordship, sending it so that we can. 4 weeks to be.
I'll give you time till 31st.
Yes.
We are posting it on 4th. Same order कर देंगे. अपील जैसी
Yes.
कोर्ट.
Item 13, second appeal 202 of 2023.
क्या चीज़ की?
But because we were keeping record and sent for court below, madam. per person because I will receive another defect also.
सेम ऑर्डर करेंगे 31st तक आपको टाइम दे रहे हैं 4 तारीख तक को हम डिसमिस ही कर देंगे फिर पीरियड की टाइम नहीं करेंगे इसलिए रिकॉर्ड देख के आप कर देंगे
Item 14, second appeal
अपील
203.
प्रेजेंट है ना सेम ऑर्डर
Item 14,
सबका
second appeal
अलग-अलग
203 of
order draw
2023.
पार्टी पोजीशन में आपको पूरा नाम नहीं देना है किसी का
So in type of 4 it's type to review. There are some surviving defect models.
What surviving?
One the CC judgment of partition suit that has to be filed. That is the and one synopsis.
substantial question of law is also missing
Yes, the
I file second appeal without substantial question as this is something which the advocate has to do and you are sleeping over it since 2023 I am giving you time till 31st by way of last indulgence and then the matter is directed to be posted on 4th same order appeal and press
Item 15. Item 15, second appeal 211 of 2023.
I pay for both. Would please and the synopsis.
board fees and
Synopsis.
so इसके लिए 4 हफ्ता आपको लगेगा नहीं इतना टाइम नहीं दे सकते एक केस में तो आप एब्सेंट ही थे अभी 10:30 बजे आना शुरू कर दीजिए
Yes, I can.
आई डोंट नो आपका भी नाम है उसमें इंजंक्शन पिटीशन का है इंजंक्शन मैटर
Yes, suit matter. Both would have the this.
सूट इज नॉट मेंटेनेबल सूट इज नॉट मेंटेनेबल यही डिसाइड किया आपको बस इसके लिए ज़्यादा टाइम नहीं लगा इतना टाइम आपको नहीं देंगे
Both.
नहीं time till 17 January is appellant present time till 17 January is granted to the appellant to remove the surviving defects preemptory if the defects are removed within time post this case on 20th of January and the appropriate time.
Item 16, second appeal 212 of 2023.
क्या defect synopsis पार्टी पोजीशन में गड़बड़ है कोर्ट फीस का क्या ही करना है बताइए कोर्ट फीस बिना लिए तो केस ही मत फाइल किया करें राइट कोर्ट फीस बिना लिए वकील साहब केस थोड़ी फाइल करते हैं जमा नहीं करते एज पर आवर एक्सपीरियंस time till 17 January is granted to the appellant to remove the surviving defects preemptory. If the defects are removed within time, close this case on 20th of January.
Item 17, second appeal 213 of 2023.
Sorry,
I am paying for time to remove the surviving defect. Totally defects are
how much time? This is also court fees.
Yes, sir. And limitation.
Typed copy, limitation petition, 18 days का limitations. By way of last indulgence for 31st one. Appellant present, time till 31st January 25 is granted to the appellant to remove the surviving defects preemptory by way of last indulgence. Close this case on 4th of
Appearance there.
For orders, item 18, second appeal 37 of 2021.
It's a big
इसमें आपको नॉट टू टेक क्यों चाहिए?
Lots of file misplace. तो इनके स्टे विद मिस्टर शर्मा डिवाइड नहीं आ पाएंगे जनरेट
आप देख लीजिए, नोटिस एक्सेप्ट कर लेते हैं, ऑर्डर्स में आए। एक बार देख लीजिए, नोटिस एक्सेप्ट करने लायक है तो नोटिस एक्सेप्ट करके आप लोग देख लीजिए। आपका फाइल मिसप्लेस हो गया है तो
No,
आपको
no, file
स्टार्ट कॉपी
is wrongly accepted. Lordship. One another junior is there. Lordship is on train. Please bring the file back.
फाइल भी लेके चले गए।
Correct.
चलिए,
Not reached. Therefore, इसको only for not to take a next week I'll do it.
नहीं आप देख लीजिए
हाँ,
ना, नोटिस
if-
एक्सेप्ट कर लेते हैं।
Yes, yes.
आप देख लीजिए, आपको लगता है कि नोटिस में आप कोई दिक्कत नहीं है, क्लोज फैमिली मेंबर्स ने ही नोटिस
हम देख
For admission item 19, contempt to late 60 of 2024.
So the order has been compared to the file which shows, but only my lord liberty may be reserved for other just
Contempt civil 862 of 24. Parties are present.
my lords.
It is submitted by the petitioner that order passed by this court dated in WPC number 6957 of 2019 dated 19/6/23 has been complied by passing a reason
my
order.
lord reason order has not been passed, but they have given me the awarded compensation amount.
Has been passed and compensation amount has been paid to the petitioner. The counsel for the petitioner submits that liberty may be reserved with the petitioner in case he has any surviving limits. Counsel for the opposite party has no serious objection to the prayer made. Considering the submissions, the contempt proceedings are hereby dropped. Liberty is reserved with the petitioner to avail his remedy as may be permissible under. Okay? Notice accept कर लें?
Yes. All well family members, all brothers and sisters. are-
Second appeal number 37 of 2021. Appellant's present. Counsel for the appellant is present. He submits that notices were issued and as per the service report, the notice has been received by the concerned respondents either by themselves or through their close family members. He submits that the notice may be accepted as validly served. The appeal has already been admitted on 6/11. Records are there. Part 2. वो record
LCR.
it has been reported by the learned court master that the records from the concerned court have already been received. Close this case under the heading for final disposal on बताइए. Considering the submissions, the notice upon the respondents is accepted as validly served. कब करेंगे?
After 4 weeks.
Pose this case under the heading for final disposal on
First week of February, Lordship. After 3rd of February.
okay on 5th of February 2025 in the supplementary class list. या थोड़ा और टाइम दे दे उनको हियरिंग्स में.
They might appear, not sure. After 6 weeks.
ज़्यादा टाइम.
और awaiting service, एक बार उधर awaiting service, awaiting appearance for 1 date lordship and thereafter it.
Okay.
That
Post
will be
on
better.
post on कौन सा डेट रखे? अभी कौन सा डेट रखे थे?
हम लोग 6 रख रहे हैं.
5th of February 24 in the supplementary cause list, awaiting appearance of the respondents.
बस तो उसके बाद 3 date.
आप तैयारी कर लीजिए.
हाँ हम
छोटा मैटर है,
हाँ,
ज़्यादा है नहीं.
छोटा.
heading final
Heading final disposal.
for hearing under order 41 rule 11 item 20 2nd April 354 of 2018.
First of all, Lords, my congratulations for the practical new year.
Sorry? Yes.
For practical new year.
Practical new year. Yes. All of you, I really wish a very happy
सबके
new
लिए
year.
शुभकामनाएं. सबको
Let's have a
ईश्वर
new beginning
स्वस्थ रखें.
and a new great year ahead. And I'm sure आपके जैसे assistants के साथ
ईश्वर
तो
की कृपा बनी
बढ़िया ही
रहे
होगा.
सबों पर. चलिए. Wait.
मेरे लिए नया बोर्ड है ये. So we'll try how much we can do.
मैं सब यहाँ हम लोग we are always ready to cooperate. जो भी हो सकता है.
पहले किए 2018 में सेकेंड अपील.
हाँ क्यों नहीं.
उस समय किए थे. उसके बाद बीच में नहीं था ये बोर्ड.
देखिए हर वकील को ही हर चीज नया होता है. अब जिस पर उसको रुचि हुआ तो सीख लिया, इसमें आगे बढ़ा, उसकी संख्या बढ़ गई,
बिल्कुल सही.
आगे बढ़ा, यही तो होता है.
हाँ बताइए.
The defendants are appellants before lordships. Now the suit filed by
ये ऑर्डर्स में है?
order 41 rule 11.
अच्छा. ये हम हेडिंग पूछ रहे हैं.
हाँ order 41 rule
Yes.
admission होगा.
Yes.
Substantial question
हाँ,
में formulate किया जाएगा.
But
Lord, now it is against the judgment of reversal. Lord, we have succeeded in the trial.
okay. You are the
Suit
tenant
was
or the
dismissed.
landlord?
हम लोग डिफेंडेंट्स हैं. सूट जो फाइल हुआ था before this subject, and there was there was that a judgment on adjudication of the materials that basing upon the Lord's sale deed executed by Rani Durgesh Kumari in the year 1968, they are in uninterrupted peaceful possession of the land property.
So let us see the trial court judgment first.
Yes. It has been reversed, Lord, without
No, let us-
breaking the reasoning.
Let us.
Yes.
Let us.
So Lordship will find from internal page 9 finding
What were the issues framed?
issues have been framed at page 7, internal page
Yes.
of the trial court judgment. Issues framed. Page 7,
Yes.
Lordship got it.
Yes.
But just below the middle, you Lordship will find.
Yes, I have seen it.
Is the suit as framed maintainable? Whether the plaintiff has got any valid cause of action of the suit, whether the suit is barred by law of limitation, whether the suit is barred by the issue of the student. Now the important issue is issue number 5, whether the plaintiff has acquired any valid title or real interest in the suit property by virtue of sale deed number 12833 or
That's
12/6/1968. This is the crux of the case. Whether the plaintiffs are in possession of this property. Now this issue has been decided against the Lord's plaintiffs.
Let us
Holding.
see the finding. Let us see the finding.
Finding Lords from page number 9, issue number 5 को ही पहले टेकअप किया गया है.
हाँ.
यही मेन है.
जी.
Whether the plaintiffs had any Lord's right at property by the judge. That's it. The issue number 5. Need I read it or your
No,
Lordship will read it?
just.
पढ़ा जाए.
क्या फाइंडिंग है असल में? पैरा 27 में देखो।
हाँ यही है, इसका फाइंडिंग आ गया है
हाँ।
कि इनको जो है वैलिड कॉज ऑफ एक्शन नहीं हुआ क्योंकि वो सेल डीड एक्सक्लूड करने का उनका जो वेंडर था उसको वो राइट ही एक्ट नहीं किया था। दैट राइट ऑफ सेलिंग द लैंड had not accrued to the vendor itself.
So vendor did not have any right to the
Had
property.
right to exclude the sale. It is with respect to 1 acre and 97 decimals of land of this Sardaha Mola. Therefore, at this finding has been reversed even when the appellate court has acceded to the fact that these are the valid documents which ought to have been with the plaintiffs. Because she was claiming the land, the sale deed was executed by Rani Durgesh Kumari. If she had no right, and that right should have been there under section, under the provision of the BLR Act, section Rule 6 and 7 of
So
19.
the vendor to the property, according to the trial court's judgment, did not have the right to execute the sale deed. And therefore, the title did not flow to the purchaser of the property. That is the finding of the trial court.
And the purchasers are the plaintiffs.
What about the possession?
Possession rights, it has been held since he had no right, therefore he had no possession. इसको देखा जाए जरा सा देख लिया जाए पेज तो पैराग्राफ 24 जरा सा काइंडली देख लिया जाए पेज 10 से थोड़ा सा उसको एलाबोरेटली डील किया है।
पढ़िए।
The learned lawyer for the defendant has pointed out that according to the plan, landlord brought some land under their khas cultivation and some established tenants. Plaintiffs claim that Rani Durgesh Kumari Devi settled a part of land to tenant, but it is not clear from the plan or evidence that which part of the land the tenants were established and over which the landlord and had in cultivating possession. The date on landing of the plaintiff stated in his cross-examination that Rani Durgesh Devi had deposited the mandatory return to the suit land, and she had also in khas possession over the suit land. But this witness is unable to say that on which land she was in khas possession, cultivated possession. Further, this witness had stated that he has no knowledge that this is important, that M form has been deposited by the Rani Durgesh Devi or not. Return has also been fixed. If it is presumed that the suit land was had khas possession of the Rani Durgesh Kumari, then she should have paid such fair and equitable rent as may be determined by the collector in prescribed manner under section 6 of the BLR Act. But there is no evidence that vendor of the plaintiff Durgesh Kumari Devi was paying such fair and equitable rent to the government. According to Rule 6 and 7 of the BLR Act Rules 1951, the land in respect of which royalty interest is claimed is to be furnished by the landlord to the collector in Form K. The collector shall then issue general notice in Form L, fixing the date, time, and place for inquiry, and then rent determined shall be entered in Form N. Rent roll is proof. This has been considered by the appellate court that the rent was determined by the collector in prescribed manner. On behalf of the plaintiff, neither M form has been produced nor Form K or Form L have been brought on record. Plaintiff had produced Exhibit 1 to 1G government rent receipts, but no rent receipts of Rani Durgesh Kumari has been brought on record. Therefore, the vendor was Rani Durgesh Kumari, and there was no rent receipt in her favor. If Durgesh Kumari had not accrued any title, how she would be the selling?
And where is the finding of the appellate?
Because can you see? And this is the
There is-
finding. Therefore, and this has been considered by the appellate. I'm just giving you ये नहीं है, ये फॉर्म नहीं है जो कि मैंडेटरी था, जस्ट हम दिखा रहे हैं। जस्ट दरअसल दिखा जाए पेज 15 जो एपलेट कोड का है, पेज 15 एपलेट कोड का बॉटम 3 लाइन केवल हम पढ़ते हैं, पूरा नहीं पढ़ के केवल बॉटम पढ़ते हैं। बॉटम 3 लाइन सेंटेंस शुरू होता है, यद्यपि कि मैं प्रतिवादी गण के विद्वान अधिवक्ता के इस तर्क से सहमत हूँ कि रानी दुर्गेश कुमारी देवी द्वारा वाद भूमि के संबंध में जमींदारी उन्मूलन के पश्चात फॉर्म एम, फॉर्म के, फॉर्म एल प्रस्तुत नहीं किया गया।
आगे
हाँ जी, और न ही श्री दुर्गेश कुमारी देवी द्वारा धारा 6 बिहार सुधार अधिनियम के तहत भुगतान किए गए मालवाड़ की विदारी रसीद की प्रति ही प्रस्तुत की गई है तथा भूमिवादी जन के नाम से दाखिल खारिज नहीं हुआ है। लेकिन रेणुका सिंह और इस नोट में किया गया है कि दाखिल खारिज के लिए भूमि का अधिकार वो स्वतः प्राप्त नहीं होता है। रेंट रिसीट के बारे में कभी अपना अपना इनका फाइंडिंग आ रहा है, बल्कि यह एक महज दखल साक्ष्य तथा सेक्शन 4 धारा इतना के पूरे की तरह 1950 के अनुच्छेद से क्या होता है कि किसी व्यक्ति कार्य या अंतर्गत हित सरकार में निहित नहीं होता, प्रावधान उच्च प्रावधान किसी व्यक्ति के निहित को सरकार में निहित।
एग्जिबिट 3 क्या है? व्हाट इज एग्जिबिट 3?
अपनी यहाँ पर पंजीकृत विक्रय मिले सेल्डिड हुआ और 68 का सेल्डिड हुआ एग्जिबिट 3। इसलिए फाइंडिंग जो है आपको यू आर टू मीट द रीजनिंग ऑफ द ट्रायल कोर्ट। अब व्हाइल रिवर्सिंग ही इज रिवर्सिंग द जजमेंट और एक ही फाइंडिंग पर आपका उसका कोई रीजन भी आप नहीं दिखला पा रहे हैं। इसलिए दिस जजमेंट इन माय हम
आप सब्सटेंशियल क्वेश्चन ऑफ
जी हम फॉर्मुलेट किया है, प्रपोज किया है, हम कहां से फॉर्मुलेट करें। आई हैव प्रपोज सम ऑफ द सब्सटेंशियल क्वेश्चन फ्लॉ
सम ऑफ द ने सिंगल सब्सटेंशियल क्वेश्चन ऑफ लॉ सफिशिएंट होना चाहिए इस केस के लिए, बताइए।
जस्ट एक ही होगा। वेदर विचार केवल एक ही ये सिनोप्सिस में है, रोमन 2 में और रोमन 4 में जो है यही एक है, वेदर रानी दुर्गेश कुमारी द वेंडर ऑफ द प्लेंटिफ हैड एनी टाइटल एंड इंटरेस्ट इन द सूट प्रॉपर्टी while executing the sale deed number so and so exhibit 2 as there was absolutely no rent received in favor of the state Rani Durgesh Kumari by the excellent law before vesting of the state। एक ये हुआ एक रोन 4 में है, वेदर उसी से जुटा हुआ है, वेदर द failure on the part of the plaintiff to prove their possession on the suit property after the vesting of the state and then fixation of the fair and equitable clearly to this side।
where is the discussion of the trial court judgment in the appellate? Where is the discussion of the trial
Of
court?
course, discuss, but
Has it been discussed?
that has not been. That is why I have brought to your lordship notice with this finding of the London Appellate Court that these documents ought to have been there to prove the title of Durgesh Kumari Devi, who was a vendor of the plant.
नहीं आप मेरी बात समझिए. What I want to say is that the appellate court has to see all the evidences. on
All the
record,
evidences.
give their finding, and at the same time, the appellate court is also duty bound to meet the reasons
Meet
of
the reason exactly.
So the reason.
Exactly.
So I just want to know from you, in the appellate
He has
court
not- he
judgment,
has
he has
not
not
made it.
discussed.
He has
right?
not.
तो this much should be sufficient क्योंकि थोड़ा सा question of reversal है, तो and title suit भी है. So this should be sufficient to frame a question that whether the appellate court, while reversing the judgment passed by the trial court with respect to issue number 5, is has erred in law and has failed to meet the reasons. that
Reasons
should be
and
sufficient.
discuss the evidences.
Reasons में discussion of evidence तो automatic हो जाता है ना, it comes automatically. तो आपका जो आपने क्वेश्चन ऑफ लॉ 1 बनाया है,
जी प्रपोज किया है जी.
तो उसमें तो आपने लिखा है ना
दो तो
कि
किया है.
क्वेश्चन ऑफ लॉ 1 देखिए, while reversing the decree.
जी.
नंबर 1
जी 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 वो है.
उतना सही हो जाना चाहिए.
हो जाएगा. इसको भी तो 2 को दिया जा सकता है. क्या कि वो बेसिस उसका वेस्टर्न डीड ही है जिसके आधार पर दुर्गेश कुमार को कहता है. तो दुर्गेश कुमार को यदि टाइटल नहीं हुआ है तो ये इसके 2 जरूरी हम समझते हैं.
इसमें जो रोमन 1 हम लोग करेंगे, पोजीशन में तो आपको कोई डिस्प्यूट नहीं है.
ना
possession में-
पोजीशन में तो हम हैं ऑलरेडी हैं.
और फाइंडिंग क्या है पोजीशन का?
फाइंडिंग तो इस फाइंडिंग के बारे में ये तो कुछ नहीं बोला. एपलेट को कुछ बोला ही नहीं बोला. इसमें तो दिया है
नहीं, ट्रायल कोर्ट का क्या फाइंडिंग है पोजीशन?
अगेन ट्रायल कोर्ट का हम पढ़ रहे हैं 14वां पेज में है. Has supported the position of the suit of the defendants. हम पेज 10 में है जो पैराग्राफ है 30 पैराग्राफ के ऊपर जो है ये करीब 5-6 लाइन पहले हम पढ़ रहे हैं. This witness has supported the possession of suit land of the defendants from procedural of Exhibit C. It appears that on date इतना 1985 there was a compromise between the parties. इसमें compromise का भी दे रहा है. Parties before the respectable person of the village which has been organized in Pindajora. P.S. According to Panchanama of the said Panchayat, the defendants would have in possession in Khata number 1 from perusal of this Panchanama, it also appears that the defendants are in possession of the Khata number 1, which is suit land constituting their work. इसलिए इसलिए possession हो गई.
ये जो डिपेंडेंट्स वेर इन पोजीशन, तो इनका तो एपलेट कोर्ट ने तो इस पर कोई
कुछ फाइंडिंग
नहीं कोई इशू फ्रेम किया था पोजीशन का. पॉइंट ऑफ डिटर्मिनेशन का पॉइंट, हाँ पॉइंट ऑफ डिटर्मिनेशन क्या है?
एक सेकंड इसका इशू जो है जस्ट
राइट टाइटल, इंटरेस्ट एंड पोजीशन, चारों इशू में है पॉइंट ऑफ डिटर्मिनेशन, राइट? पोजीशन के बारे में कोई फाइंडिंग है एपेलेट कोर्ट?
नहीं, एप्लेट को कहाँ पे देख लिया जैसे नहीं है। यहाँ पर कितने बोल रहे हैं, ये कह रहे हैं, जो लिख रहे हैं इसको, पेज 16 जो है इंटरनल पेज, ट्रायल कोर्ट एपेलेट कोर्ट का जजमेंट, इस प्रकार अभिलेख पर उपलब्ध मौखिक एवं दस्तावेजी साक्ष्यों के अवलोकनांत मैं पाता हूँ कि वादीगण अपीलार्थी गण के प्रदर्शित विक्रय अभिलेख इतना के आधार पर वाद भूमि पर वैध अधिकार एवं रैयती हित प्राप्त है तथा वादीगण अभिलार्थी भूमि का दखल भी प्राप्त करने के हकदार हैं।
रिकवरी ऑफ पोजीशन का है
के लिए
मतलब इसका मतलब पोजीशन आप ही का हो गया,
पैसा हमारा
मतलब रिकवरी ऑफ पोजीशन का
हाँ है,
उनको राइट दे रहा है
दे-
एपेलेट कोर्ट,
जी,
इसका
जी।
मतलब पोजीशन आपका है।
पोजीशन मेरा है तो उसको तो
ठीक है, लिखिए। Heard the learned counsel appearing on behalf, learned senior counsel appearing on behalf of the appellants. This is second appeal number 354 of 2018. The learned counsel for the appellant has submitted that the present second appeal has been filed against the order of reversal. The title suit filed by the plaintiffs, being title suit number 30 of 1995, was dismissed. And the main issues, which were issue number 5 and 6, issue number 5, and the main issues, which were issue number 5 and 6, were decided against the plaintiff. The appellate court has reversed the judgment only with regard to issue number 5, and so far as only with regard to issue number 5 as framed by the learned trial court, and so far as issue number 6 regarding possession is concerned, the appellate court has directed that the plaintiffs would be entitled for recovery of possession. The learned counsel submits that thus the possession of the defendant with regard to the suit properties stood confirmed by the trial court as well as by the appellate court. He submits that the appellate court, while reversing the judgment, while reversing the decree, has not met with the reasoning given by the learned trial court and has not considered the documents, evidences on record properly. Considering the submissions and having gone through the impugned judgments, this appeal is admitted for hearing on the following substantial question of law. ये रोमन 1 कर लेते हैं,
1 और 2 को कर
1 and 2.
जी
1 and 2 ये ऐसे रहता है सिनॉप्सिस में, ये फॉलोइंग सब्सटेंशियल क्वेश्चन ऑफ लॉ, राइट? और इसको जो है यहाँ इसको कोट करते हैं, इशू नोटिस टू द रिस्पोंडेंट्स। कहाँ की पार्टी है?
पार्टी तो बोकारो का है, लेकिन पार्टी से बहुत कहाँ कहाँ हैं ये लोग सूट यही लोग फाइल किए थे, तो इसमें पार्टी तो नए साथी पार्टी है। पहली बार इसी पर जाएगा, जब लौटेगा तब देखा जाएगा।
Respondent number 1 to 7 and respondent number 9, 15, 16, 17, 18, 19 through the concerned police station. Through ordinary process.
अभी ordinary process पर जाने
Just
दिया जाए पहली बार।
through ordinary process and under speed post. So far as respondent number.
अभी speed post
Just a
पर दिया
minute.
जाएगा।
हाँ, speed post पर दिया जाएगा. And so far as respondent number 7, respondent number 8 and respondent number 10, 11, 12, 13 and 14 are concerned, let the notices be issued through speed post as well as registered cover with AD. Office registered cover with AD to speed post हो जाएगा?
पहला जो नोटिस, पहला जो है समझ जाएगा, जो मेरा
नहीं, ऑर्डिनरी प्रोसेस में बिहार से कहाँ से, वो तो सर्विस ही होने में बहुत दिक्कत है।
नहीं, वो तो होगा, लेकिन स्टेप है।
कोई बात
ऑर्डर,
ऐसा कोई जरूरी
ऑर्डर
नहीं है, रजिस्टर्ड पोस्ट से जा ही
नोटिस जाएगा,
रजिस्टर्ड पोस्ट से जा सकता है ना, इसको मना ही
नहीं, जैसा नहीं मना ही नहीं।
रजिस्टर्ड पोस्ट विद एडी कर दीजिएगा इन लोगों का। द रिक्विजिट्स वी फाइल्ड बाय द
केवल रजिस्टर्ड पोस्ट विद एडी सबको कर दिया
ऐसा नहीं
और ऑर्डिनरी
नोटिस हम लोग अपने हिसाब से
ऑर्डिनरी प्रोसेस भी होगा ना,
ऑर्डिनरी प्रोसेस।
हाँ जी, ऑर्डिनरी
प्रोसेस
एंड रजिस्टर्ड विद एडी
एंड रजिस्टर्ड विद एडी। सो फार एज जो बोकारो वाली पार्टी है
जी,
जो दिल्ली वाली पार्टी है और जो बिहार वाली पार्टी है, उनको सिर्फ रजिस्टर्ड पोस्ट,
केवल रजिस्टर्ड ऑब्लाइक,
ठीक है, हो जाएगा विद एडी। स्पीड पोस्ट हटा दीजिए। The requisites we filed by 10th of January.
2 सप्ताह दे
17th of January.
जी जी।
Post this case on 21st March, awaiting notice. सर्विस रिपोर्ट तो आएगा ना, नहीं तो फिर अननेसेसरी सर्विस के लिए पेंडिंग रह जाए। कॉल फॉर द रिकॉर्ड्स फ्रॉम द कंसर्न, लेट दिस ऑर्डर बी कम्युनिकेटेड थ्रू फैक्स। एग्जीक्यूशन कुछ केस फाइल हुआ,
उस सबको हमको अभी एक्चुअली
इसलिए पूछ रहे हैं क्योंकि एग्जीक्यूशन से ही पता लग जाएगा,
उनको
रिकवरी का डायरेक्शन है ना।
एक्सक्यूशन गैरेजरी होगा, पार्टी हमको कांटेक्ट हुआ ही नहीं, प्रॉब्लम है, इसलिए हम सभी का सभी से।
Item 21, second appeal 49 of 2020.
फाइल खोली और क्या मैटर है बताइए.
मैटर यही है कि हम सूट फाइल किए थे and thereafter no defendant appeared filed WS ex parte judgment against me. I had claimed the right title interest in respect of the suit purpose. And the first revision survey, my possession with regard to 2/9 of the share of the property in my favor. But in the revisional survey, I was only provided only one share. I had raised an objection before the settlement officer, revenue officer. Thereafter, the plaintiff lost, and he filed thereafter the present title suit. And in the title suit, no defendant appeared. This is a party judgment.
And the suit was decreed.
The suit was not decreed.
So suit was dismissed in spite of the fact that nobody appeared.
Nobody appeared.
So
And
क्या
evidence was read by the plaintiff, madam. Already the both the record of right has been marked against, as well as the rent receipt has been marked against. Their statement is there, even though the suit has been dismissed without by way of ex parte. Now the trial court has stated that if there is a bar in the CNT with regard to maintainability of the suit, so far as the against the revenue court, 87, under section 87, the objection was raised with regard to the record of right. But on this point, there is judgment of full bench, my lord, of the Patna High Court, my lord, that even the revenue court has passed the order, the suit is maintainable. The full bench judgment, my lord.
बताइए.
This is not full bench, division bench, it's full bench. 21, paragraph number 2.
The appellant is present. The appellant has submitted that. The appellant was the plaintiff before the trial court, and he has lost in both the courts. He submits that the defendants did not file any written statement, and the suit has been dismissed by holding that the suit was not maintained. He has relied upon the judgment passed by full bench of Patna High Court Ranchi bench, reported in 1987 BBCG 202 within bracket FB. He has submitted that he is not fully prepared in the present case, pose this case for further hearing tomorrow. कल आ जाइए एक बार देखिए. कल आ जाइए. Tomorrow मंडे क्यों? कल नहीं आ रहे क्या कोर्ट? नहीं ऐसे ये कोई मतलब नहीं है. पहला दिन आप रेडी नहीं है, ये अपने आप में बहुत गलत बात है.
केवल हम जेनेटिकल टेबल पर हम बता रहे हैं.
कोई बात नहीं, आप आइए, आप अपना बहस करिए.
इसको
Item 22, second appeal 52 of 2020.
This second appeal made by the plaintiffs appellant against the judgment of affirmance. This suit was partly decreed in favor of the plaintiffs appellants. The remaining part was challenged before the appellate court without recording any finding by a non-speaking, practically non-speaking judgment, ignoring the mandatory provisions of Order 41, Rule 31 of the CPC and the settled principle of law, affirm the trial court judgment. So far, the dismissal of the suit to that extent. Now, the facts of the case note is that the suit,
Any cross appeal filed?
no cross appeal. Now, the suit was filed by the plaintiffs for partition to the extent of 2 by 9th share in respect of Schedule B and C property. There are three schedules. Schedule A is the common property acquired by their common ancestor. Defendants number 1 to 7 and the plaintiffs are the legal heirs of the common ancestor, that is not in dispute. Now the second prayer is that the defendant number 2, being son of the plaintiff number 1 and brothers of the plaintiff number 2 and defendants number 1, 3 to 7, he, taking advantage of old age of his father, he was looking after the property and got a registered sale deed in his favor, that is Exhibit 3, by at the fag end of the life of his father. And that was never acted upon. Now, after death of their husband of the plaintiff number 1, and
What do you mean never acted upon?
acted upon, that was not mutated, no possession.
Maybe, but there is a sale deed.
That was not, there was a sale deed. It was not within the knowledge of the present plaintiff. Then a meeting was held when for the first time, after he disclosed that the property was acquired by him, although they were in common possession, joint possession, all throughout, that has been held by the trial court also. Now, my Lord, your Lordship will find that the learned trial court is framed issues, if your Lordship may kindly see para 6 of the trial court judgment. Para 6.
Yes, please.
Yes, page number 45, running page 44. So far, issue number 5 is concerned, your Lordship may kindly see whether the Schedule C property purchased by registered sale deed dated 30th May 1994 out of joint family funds of the plaintiffs, including defendant number first party. Then para 6, issue number 6, whether the defendant number first party Dharmendu Dev, Bablu Bhagat had got any right to transfer and sold the Schedule C property to the defendant number 8. And issue number 7 is whether defendant number 8 derived any right, title, interest and possession over Schedule C property by registered sale deed dated 29th of May 2000.
There are two registered sale deed.
In fact, not the one sale deed in respect of not the defendant number 2 and the another sale deed not Exhibit A, Exhibit 1, that is not 29th of May 2000. The relief was sought for declaring that sale deed to be null and void. So there are two reliefs. First relief relates to partition of 2/9 share of the plaintiffs, and second relief with regard to declaration with regard to the sale deed dated 29th of May 2000 to be null and void. Now, your Lordship may kindly see issue number 5 has been dealt by the learned trial court. Before that, your Lordship will kindly see para 7, the para 8, the documents which were placed on record, that is page 45. The next page after the issues were framed.
You can refer to the internal page because your page numbering is not tallying.
So, page number 13, नीचे में page
हाँ,
number 13.
हाँ, ठीक है.
13 में जो देखेंगे Exhibit 1 is the certified copy of preliminary decree. The case is that in 1929
there was a partition.
There was a partition between Devchand and Motilal. Motilal is son of Devchand. Both were got themselves. There had been a partition in 1929. Devchand and Motilal got their share in the entire property in that 1929. For that purpose, preliminary decree entitled partition suit number 52/29 and final degree in allotment sheet, that is exhibit 2, these are not in dispute. Then what exhibit 3 is the sale deed executed by defendant number 2 in favor of defendant number 8, claiming that it was his own property. That is under challenge. Exhibit 3A and 3B, these are the two sale deeds by which the defendant number 2 claimed to have got the property from his father by registered sale deeds. That is exhibit 3 by A and 3 by B. Then your lordship may kindly see the issue number 5 has been dealt by the learned trial court in the paragraph 11. The relevant part, your lordship may kindly come to ultimate finding. Page running page 16, inner page 16, concluding part of para 11. नीचे में पेज नंबर. Therefore, the submission has been recorded. This is the submission on behalf. I am not reading it. Submission by both the parties. Even the defendants number 1, 2, who is the vendor, he also supported the case of the defendant. That will be evident from his written statement and para 12 the submission. Then your lordship may kindly see para 14 starts the discussion. That is inner page 19. The issue number 5 and 6.
Yes.
Now, ultimately, your lordship may kindly see page number 20. PW, since these issues are very vital and exigent, therefore they are taken up for adjudication at the first instance. PW1 and PW3 have asserted in their evidences that Motilal Bhagat in his old age was quite unable to look after and manage the property belonging to him. As such, Sri Dharmendu De Bablu Bhagat, who was sitting idle and being the eldest son, used to look after and manage the entire movable and immovable property. At the fag end of his life, Motilal Bhagat was become seriously ill. Taking advantage of ill health and incapability to look after the manage the property by Motilal Bhagat, said Dharmendu Dev Bablu Bhagat managed to purchase the landed property described in Schedule C by registered sale deed 30th May 1994 in his own name from the income of joint family fund. Though the sale deed number such and such 30th May 1994 stands in the name of Bablu Bhagat, but the landed property covered therein was purchased from the joint family fund and it is all along in peaceful joint possession of all. Motilal Bhagat died on 16/9/94 within a period of 3.5 months from the date of execution of this sale deed, leaving behind his wife, Srimati Bhanumati Bhagat. She is the appellant number 1. 4 sons, such and such. One of them is appellant number 2, and others are defendants. And 4 daughters, such and such. Now, who have inherited the property described in Schedule B and C of this plan and in peaceful joint possession thereof. After death of Motilal Bhagat, there was no good and harmonious relationship among the sons of Motilal Bhagat, and in this said family meeting was held on 10th of April 2011. Sri Dharmendu De alias Bablu Bhagat said that Schedule C land was purchased by him, and he further disclosed that he has already transferred the same to the defendant number 8 by registered sale deed dated 29th of May 2000. Dharmendu Dev Bablu Bhagat had no source of income of his own, as such Schedule C property was purchased from the joint family fund. Therefore, he had no right to transfer the same. Defendant witnesses DW1 such and such adduced on behalf of defendant number 8. He is the purchaser, stranger to the family. Now, Bablu Bhagat stated that Bablu Bhagat purchased land through registered sale deed dated 30th May 94 from Vijay Singh on the payment of total.
Who is Vijay Singh?
Vijay Singh is the seller to Bablu Bhagat. Our case is that Bablu Bhagat has purchased it at the fag end of the old father from a.
This sale deed dated 35/94.
Not by father.
Just
I was wrong in submission. I stand correct. But it was purchased in the name of Bablu Bhagat individually out of the joint fund. That is the case.
So he did not purchase it
No,
from his
father. I am sorry, brother. I stand. Subha, पढ़ लीजिए थोड़ा, हम सोचे कि टाइम नहीं
अच्छा साथ साथ पढ़ लीजिए।
टाइम नहीं
पढ़िए
लगे,
पढ़िए।
इसीलिए जो हमको दिमाग में आया कि पिताजी से कहते, दैट इज नॉट द फैक्ट, आई स्टैंड करेक्ट। He purchased from the joint family fund, that is our case, in his name from another person, Vijay. Now this dependent is paying government rent for his purchase.
नहीं नहीं आगे आगे पढ़िए।
Yes.
डिफेंडेंट नंबर
Vijay
1
Singh on the
2
payment of consideration money of 30,000 and was in exclusive possession thereof, subsequently sold it to this defendant to meet his family expenses and business. This defendant is paying government rent for his purchased land of 1 acre 15 decimal and obtaining government rent receipt by mutation case number such and such. The plaintiffs and defendants never raised any objection to the said mutation proceeding despite having knowledge of it. Plaintiffs pleaded in their claim that the fag end of his life of Motilal Bhagat was ill and taking advantage of ill health while managing the property of Motilal Bhagat. Bablu Bhagat managed to purchase landed property enumerated in Schedule C by registered sale deed number such and such in his name from income of joint family fund. This is our. While defendant number 8 pleaded in his written statement that Dharmendu Dev, Bablu Bhagat from his income and earning purchased the said Schedule C property in 1994, which was later on conveyed to him on 29/5/2000. He negated the land property enumerated in Schedule C was purchased from joint family fund. Exhibit 3 and 3/B are the certified copies of the registered sale deed dated such and such. Both documents are rattling and stringent to manifest that the landed property enshrined in Schedule C of the plan was purchased by Dharmendu Dev, Bablu Bhagat, and later on the same was transferred to defendant number 8 in the year 2000. Both documents do not whisper that Schedule C property was purchased by Bablu Bhagat from the joint family fund of the plaintiff and defendant first party. Had there been any purchase from the joint family fund of the plaintiff, the defendant first party, then said matter might have been elucidated in the recital of the sale deed pertaining to Exhibit 3 and 3/B. Oral versions of the plaintiff cases go to manifest that Dharmendu Dev Bablu Bhagat had no source of income of his own, as such Schedule C property was purchased from the joint family fund of the plaintiffs and defendants first party. The oral version of the plaintiff cases does not get corroborated and invigorated due to sanctity of immaculate and stringent documentary evidences. The recitals enumerated in Exhibit 3 and 3/B go to dissipate and palliate the pleadings enshrined in the plaint that the Schedule C property was purchased from joint family fund of the plaintiffs and defendants first party. Not a single congruous and stringent document was produced on behalf of the plaintiff to elucidate the consideration amount for purchasing the landed property in Schedule C was withdrawn from joint family fund of the plaintiff and defendant first party. Moreover, no account statement of joint family fund pertaining to the plaintiffs and defendants first party was adduced on behalf of the plaintiffs to verify their pleadings, and Dharmendu Dev was purchased that the scheduled property from joint family fund of the plaintiffs and defendant first party. It has elaborated the whole pleadings delineated in plain. It has given.
There is no evidence that there was joint
No, in
joint
fact,
family fund. It's a
so
case
far
of no
joint family
evidence.
fund is concerned. The oral evidence of the all co-sharers, even the defendant number 2, if your lordship may kindly permit me to refer to written statement which is joint in nature, he also admitted this fact. Now this question is not section 58 says of the Indian Evidence Act. The facts admitted need not be proved. Now if the vendor of defendant number 8, he being defendant number 2, he admits in his written statement it was a joint family property and it was purchased in his name, then what is needed will not to be proved. And secondly,
Where is the admission?
That is the reason that is my submission. If your lordship may kindly see the written statement first of all.
Filed by defendant number 2.
Yes, your lordship may kindly see
Where is
defendant's number. Para 6.
Or defendant number?
That is not para 6, that is page number minute just नीचे पेज नंबर 4 पेज नंबर 4
Yes. Page number 4 is just a schedule of the property.
पेज नंबर 4 ऊपर में पेज नंबर 4 टाइप करो
Plaintiff's place
उसके
and
बाद पैरा 6
defendant number 1, 2. आप 2 का
Two.
बात कर रहे हैं ना?
तो 1 2
2 is the purchaser of the property in the year 1994.
वही ना बेचे हैं 8 को
हाँ ठीक है. 2 का written statement बताओ.
वही तो बता सबको एक साथ
Defendant number 2 is what? नहीं, 8 का अलग written statement है.
8 का तो परचेजर है
आप purchaser हैं, आप defendant number इनका
अब
बताइए.
जो देखा जाए डिफेंड नंबर 3 इथे 3 धर्मेंदु देव एलियास भागलू भगत
Defendant number 3.
यस
Defendant number 3 का written statement कहाँ?
दिए ही नहीं 1 2 4 to 7 और डिफेंड नंबर 3 एक्स पार्टी पैरा 5 डिफेंड नंबर 3 पैरा 5
बहुत अच्छा है. प्रॉपर्टी बेच दीजिए, उसके बाद एक्स पार्टी करा दीजिए.
हमारा उसमें क्या खाता है हमको केस लड़
एक लड़िए केस.
नहीं डिफेंड नंबर 3 बबलू भगत डिड नॉट अपीयर therefore proceeding against him was fixed by an ex party another defendant supported only defendant number 8 is the purchaser of defendant number 3 and defendant number 3 is not before the
कहाँ लिखा है defendant number 5 का एक्स पार्टी?
ये तो हुआ पैरा 5 उसी पेज नंबर 4 जिसमें टाइप किया हुआ प्लेंटिफ केस के बाद
आपका कुछ टैली नहीं करता.
नहीं तो हम जैसा
इंटरनल
सर्टिफाइड
पेज नीचे से है ना 9.
नहीं ये देख रहे हैं ऊपर में दिया है 4 नंबर
नीचे एक रनिंग पेज नंबर है, आप देख रहे हैं? उसी से रेफर
नंबर
करें.
57
नहीं नीचे एक टाइप्ड रनिंग पेज नंबर है.
वो तो रनिंग पेज है ना जो
हाँ रनिंग पेज.
ये रनिंग पेज में तो 3 के बाद 4 ही है 4 है ऊपर में भी 4 टाइप किया हुआ सर्टिफाइड कॉपी में ही 5 4
टाइटल पार्टीशन सूट नंबर्स नीचे पेज नंबर 6 राइट हैंड साइड में एकदम दिया हुआ है, दिख रहा है?
पेज नंबर 6 तो आगे बढ़ गया इशू के पास अच्छा ठीक है वेलोसिटी हम appellate कोर्ट का
बताइए कहाँ है?
हाँ ये appellate कोर्ट का जजमेंट
नहीं, appellate कोर्ट का जजमेंट का कहानी मत सुनाइए, आप हमको ट्रायल कोर्ट का जजमेंट.
पैरा 4 में है 1 2 4 to 7
1 2 4 to 7.
हाँ.
3 कहाँ है?
1
3 का कहानी कहाँ लिखा है?
यस पैरा 6 पेज पैरा 6 इश्यूज के ठीक ऊपर on 15/3/2012 ex parte proceeding was ordered to be initiated against defendant number 3 वही चीज appellate कोर्ट भी लिखे हैं कि did not appear इसलिए ex parte दोनों एक ही बात है. Similarly
ये जो admitted fact आप बोल रहे हैं defendant
इसलिए कि
number 3
when it
का,
was not contested and no pleading of defendant number 3 before the court the court has not wrongly and erroneously presumed कि इनका कोई एविडेंस नहीं. सवाल है कि facts admitted now it will be presumed that he has admitted and the learned appellate court has recorded his finding only on presumption. And order 41 rule 31 says he has to deal he is the final fact court of fact he has to deal even all issues. Now your lordship may kindly see the finding of the learned trial court that is नीचे में जो पेज नंबर 21 पढ़ लिए थे. अब उसी का जो देखा जाए पेज नंबर 23 पेज नंबर 23 ऊपर में टॉप
हाँ.
hence from the recitals dedicated in exhibit 3. Now exhibit 3 is a registered sale deed executed in favor of defendant number 3. It cannot be a sole document. It is not
recital में होगा ना लिखा हुआ?
recital में नहीं होने से वो समझा नहीं जाएगा, प्रिज्यूम नहीं कर सकते हैं कि it is not from joint fund. Exhibit 3 goes to manifest. Schedule C property was purchased by such and such from his income. From his income what है नहीं. Exhibit 3 में अपना income sum खरीद रहे हैं. That is also missing. That is also an error of record. How the court presumed it? A sale deed does not speak that it is from his own income. So if there is no such a contents in this sale deed, how the court could presume that it is his own property out of his own fund? Then, my lord, your lordship may kindly come to, my lord, page number 25, another finding. Issue number 5, second part. Issue number 5 has been decided by assigning congruous reasons enunciated above. It is well lucid and candid that Dharmendu Dev, Bablu Bhagat purchased Schedule C landed property from source of his own income, of his own, and the same was not purchased out of joint family fund of the plan. So how he could deduce from this sale deed when there is a missing of these words that it is from his own income? It is on presumption, and that has been done by the appellate court also. Now your lordship may kindly come to, my lord, page number 33. Page 33, para 16. Page 33.
Just a minute. Possession किसका बताएं? What is the finding on possession?
Nothing.
No issue was framed on possession.
No, your lordship, just see the again issue. Issue, my lord, page para 6. Para 6, page number 12. Is the suit maintainable?
Para 7. Issue number 7 का क्या finding?
Whether defendant number 8 derive any right, title, interest and possession. You will see just see issue number 7. ये bill की है. 5 and 6 para 14 में है, page 19. उसके बाद accordingly issue number 5 is decided. उसके बाद issue number 6 का finding होगा page number 25. अब आइए para 15 issue number 7 and 8. Page 25 से start करो. You will see just see where page number 28 is the finding. Hence, the evidentiary value of these documents remain intact, and these are immaculate and rattling documents to evince that the registered sale deed number such and such dated 29/5 was acted upon by the vendee in whose favor Schedule C property was alienated. Moreover, not a single rent receipt has been filed by the defendants or plaintiffs or defendant.
आप इसको पढ़िए, ऊपर से पढ़िए.
It is well manifest,
Yes.
candid, that the Schedule C property was legally alienated in favor of defendant number 8 by Dharmendu Dev, Bablu Bhagat on the basis of registered sale deed dated 29th of May 2000. The defendant number 8 procured valid right, title, interest over the Schedule C property. Exhibit B and B by 1 are the original rent receipt issued in favor of defendant number 8 by Anchal Office. It is pertinent to mention here the rent receipts are issued by the circle officer only after Jamabandi and mutation. Exhibit B and B by 1 have been issued by Anchal Office in favor of defendant number 8. Those documents have not been controverted and corroborated by the plaintiffs, the defendants number 1 to 7. Hence, the evidentiary value of these documents remain intact, and those are immaculate and rattling documents to evince that the registered sale deed dated 29/5/2000 was acted upon by the vendee in whose favor the Schedule C property was alienated. Moreover, not a single rent receipt has been filed by the defendant or defendants number 1 to 7, which could divulge that the plaintiffs and defendant number 7 are in joint possession over the landed property of Schedule C. Hence, from the flawless and innocent evidences of defendant number 8 coupled with the rattling documents go to evidence divulge that the registered CVT dated 29/5/2000 was acted upon and the same document exhibit 3 is not a void document. No finding with regard to possession.
यही तो है finding with regard to possession.
फाइंडिंग कहाँ है कि उनका पोजीशन हुआ and rent receipt cannot be relied upon and rent receipt cannot presume that he is in possession.
Rent receipts are evidences of possession.
But that cannot be relied upon. It is a full-fledged trial in a competent civil court. Has to
Rent
make-
receipts have
issue was framed.
evidentiary value so far as possession is concerned.
Issue was framed, right title, interest and possession. What is possession there?
You see, the
But
property
no
was
finding.
the property was purchased from third party,
Yes, yes.
right?
Yes.
And then the property was mutated in favor of the
Yes.
purchaser, right? Who was just one of the members of the joint.
From
Now-
one member. From one
Right.
member of the joint.
Only the mutation was only in favor of one member of the joint family.
No, no, in respect of Schedule C.
In respect of Schedule C only, we are concerned with Schedule C, right?
Schedule
The-
C, but my humble submission, Lordship, rightly put a question.
Where is the evidence to show that he had purchased the property from the joint family fund?
That is our evidence which we have already discussed. I have already read. Now, my learned court below has relied upon only Exhibit 3. Exhibit 3 does not speak that it is from his own income, he purchased it. And the court presumes that it has been purchased in his name, therefore it will be presumed. So, presumption cannot be a finding. And number one. Number two, when you are framing an issue with regard to right title, interest and possession, where is the finding on possession of defendant number 8? Secondly, your Lordship, may kindly see section 44. Section 44 of the transfer of property. Just see what right has been devolved upon the defendant number 8. If that is so, this aspect has been not been considered.
Defendant number 8 was made
Stranger.
party, not
Yes.
made.
Because
you were the plaintiff, you made defendant number
Yes,
8.
because I have challenged the sale deed.
Yes, you have challenged the sale deed,
Yes,
right?
that is my challenge is on 3 grounds. First of all, you will just see for a moment section 44 of the transfer of property. For a moment.
And what about the remaining part of
Yes,
the
that has been allowed in favor of the plaintiff. Lordship, may kindly see page number 33. Page number 33. Issues number 9 and 10. Towards middle. Page 33. Niche type. It has been earlier adjudicated. 33. It has been earlier adjudicated that plaintiffs and defendant number 1 to 7, including defendant number 3, have a joint possession, interest, title over landed property in Schedule B of the claim. Accordingly, plaintiffs are entitled for their 2/9 share in respect of landed property described in Schedule B of the claim. That has been allowed, decreed in my favor, in our favor. Issue number 9
इसके
and
ऊपर वाला पैराग्राफ पढ़िए.
0. Since the suit property enshrined in Schedule C of the plaintiff does not come under the joint possession and title of the plaintiffs and the defendants number 1 to 7, therefore the suit property cannot be exposed for partition. This is contrary to section 44. Your Lordship, just see for a moment.
Yes.
Transfer by one co-owner, where one of two or more co-owners of a more property legally competent in that behalf transfers his share of such property or any interest therein. The transferee, on defendant number 8, acquires as to such share or interest, and so far as is necessary to give effect to the transfer, the transferor's right to joint possession or other common or part enjoyment of the property and to enforce a partition of the same, but subject to the condition and liabilities affecting at the date of transfer the share or interest so transferred. Therefore, my lord, the right will be confirmed only after seeking partition by the defendant number 8. It cannot be an absolute sale. It is a sale by a co-sharer. This aspect has not been considered. Then your lordship just come to appellate court judgment. Appellate court judgment. Which I was referring at page number 4, para 5. Third trial court judgment में बात वही लिखा हुआ है. Defendant number 3, Bablu Bhagat did not appear, therefore proceeding against him was fixed ex parte. Then your lordship may kindly come to me. Issues have been quoted in para 8.
Para 6 पढ़ी.
Para 8 में
Para 6 भी पढ़ी.
Para
Kindly read para 6 first.
60.
6.
Para 6 is the case of the
कोई बात नहीं आप पढ़िए.
defendants number 1 to 4 पढ़ दें.
ये defendant number 1 to 4.
और वो जो वहाँ भी लिखा है एडमिट से वो 3 नहीं है.
Just a moment. Plaintiff.
प्लेंटिफ का हो जाए पैरा 4 में है प्लेंटिफ केस. पैरा 5 में डिफेंड नंबर 3 के बारे में लिखे.
ठीक.
पैरा 6 में हो जो डिफेंड नंबर 1 to 4 to 7 they have supported the plaintiff. They are also the legal heirs. They have supported. They have also said that the Bablu Bhagat had no source of income of his own. Bablu Bhagat is the eldest son. He was entrusted to look after and manage, and he did mischief, got this salary in his sole name, although he always assured that other family members that it is purchased in the name of Motilal Bhagat, though the land purchased through registered sale deed stand in the name of Bablu Bhagat. It is always been in present joint possession of the plaintiffs and defendant number 1 to 7. The defendants have got no objection if the suit property is partition. So they are supporting the plaintiffs. Now, defendant number 8 is the purchaser who contested the suit. Issues have been incorporated in para 8. Trial court में जो issue frame हुआ था. Now, your lordship may kindly see the Order 41 Rule 31 पढ़ा जाए CPC. Your order 41 Rule 31 पढ़ दें. Contents and dates and judge signature. The judgment of the appellate court shall be in writing and shall state small a if points for consideration determination that is lacking in the appellate court judgment. So just see for a moment.
Para page 8 में है ये appellate court.
Page 8 में. Yes, that is whether schedule C property. I'm just
है ना point for determination. Lacking तो मत बोलिए.
नहीं lacking नहीं, हम कह रहे हैं उसका finding है. Your lordship just see he framed 4 issues.
Yes, framed 4 issues नहीं.
But
These
did
are
not-
the point of determination framed by the appellate.
Frame किए.
Frame किए, lacking मत बोलिए.
Lacking of the finding हम सब बोलने में गलती हुआ. He
बोलने में गलती
I
मत
was-
करिए. बड़े आराम से बहस सुन रहे हैं और बहुत आराम से बहस करिए. दूसरा कोर्ट में जाना है तो यहाँ मत आइए क्योंकि हमको
बता
टाइम
नहीं रहे
लगेगा.
हम धीरे-धीरे बोल.
इसलिए ये मत बोलिए कि पॉइंट ऑफ डिटर्मिनेशन फ्रेम नहीं
हम
है.
lacking what इसलिए बोल रहे हैं.
अच्छा नंबर 2 में आइए. द डिसीजन देयर ऑन.
Yes, point number 1, 2 and 3 एक साथ डिसाइड.
हाँ ठीक
Point
है, एक
number
साथ कर ही
one में
सकता
है।
है डिसाइड, मना ही नहीं है.
मना नहीं.
ये जो ऑर्डर 41 रूल 31 है
कंप्लायंस होना
उसका कौन सा पोर्शन का कंप्लायंस नहीं हुआ ये बताइए.
वही हम बोलना चाहते हैं.
पॉइंट्स फॉर डिटर्मिनेशन दिया.
हाँ, उसके बाद
डिसीजन ऑन द पॉइंट फॉर डिटर्मिनेशन बताइए. इसमें ए बी सी डी में से किसका कंप्लायंस नहीं.
वही हम
फिर हम लोग देखते हैं क्या.
उसी का फाइंडिंग पढ़ने के बाद हम बोल रहे हैं.
नहीं पहले आप बता दीजिए इसमें से कौन से स्टेज का कंप्लायंस
पहले
नहीं
हुआ
है.
पॉइंट्स फॉर डिटर्मिनेशन जो पैरा 8 में बोला पेज में। अब डिसीजन देयर ऑन वो हम पढ़ दे रहे हैं। उसका तीसरा में है रीजंस फॉर डिसीजन। चौथा में वेदर डिक्री अपील फ्रॉम इज रिवर्सल वेरिट वो तो कर दीजिए,
वो कॉन्सिक्वेंशियल है।
वो कॉन्सिक्वेंस है। ए बी सी 3 में से ए तो हुजूर देख लीजिए। अब हम भी देख रहे हैं। अब बी के बारे में हुजूर हम बी और सी पॉइंट नंबर 1, 2 एंड 3 एक साथ कर दो। पॉइंट नंबर 1 है कि सेल्डी डेटेड 30/5/94 was purchased from the joint family fund of the plaintiff and defendants first party। 2 में है whether बाबलू भगत had got right to transfer। 3 में है defendant acquired any right, title, interest or possession। यहाँ भी possession वर्ड है जो इशू में था। और 4 में है लैंडेड कोर्ट बिलो प्रॉपर्ली एप्रिसिएटेड। अब जो देखा जाए 1, 2 एंड 3 एक साथ कॉमन फाइंडिंग क्या लिख रहे हैं पढ़ पैरा 18। All these 3 points are being taken up together for the sake of convenience as they are interrelated to each other। Plaintiff's case with respect to Schedule C property is that at the fag end of his life, Motilal Bhagat was seriously ill and most of time he was bedridden, taking advantage of ill health and incapability to look after and manage the property of Motilal Bhagat. Dharmendu Dev Bablu Bhagat managed to purchase the landed property by schedule in Schedule C below by registered sale deed dated 30th May 94 in his own name from the income of joint family fund। Issue number 5, the learned put below also deals with the same point। Perusal of 3 by B, it appears that Schedule C property was purchased by Schedule sale deed dated such and such in the name of Bablu Bhagat। The presumption would be, this is my summation, the presumption would be that in the absence of any evidence to the contrary was the self-acquired property of purchased Dharmender Dev Bablu Bhagat। Plaintiffs have merely reiterated the oral evidence that Bablu Bhagat, taking advantage of illness of Motilal Bhagat and being Karta of the family court, the sale deed executed in his own favor by giving an impression to other family members that the said sale deed was executed in favor of Motilal Bhagat। Mere oral evidence in this regard will not rebut the presumption raised in favor of purchaser by Exhibit 3 by B। Plaintiffs have not brought on record any evidence as to what was the source of joint family income, from where the money of purchase of Schedule C property was arranged. Mere allegation that Bablu Bhagat deceived the other family members got the sale deed executed in his favor does not suffice। Since this sale deed was executed in favor of Bablu Bhagat, it could be deemed that it was purchased by him and not by joint nucleus of the plaintiffs, defendant first party. Thus, the point number 1 is decided against the plaintiff। Since Bablu Bhagat got right title interest of Schedule C, Exhibit 3 by B, he had ever right to transfer in favor of defendant number 8. The said property was transferred in favor of defendant number 8 by Exhibit A. Point number 2 and 3 are also decided. No finding.
Where is the nucleus of the, you see,
No
in
finding.
order to prove that the property was purchased from the funds of joint family property, 2 things are required to be proved. First is that the family was a joint family, right? That has been proved because for portion of the property there is a direction for partition. Second is the source of income, the source of the fund, right? Merely by stating that it was joint family fund is not sufficient. You have to prove that what was the source of the joint family
Therefore.
fund. That is totally absent.
Therefore,
You tell
therefore
us.
defendant number 3 is the best person
No, he
because he
ये
is
सब
the
ये जो है
purchaser।
ना,
He could have
you
stated.
see, बहुत अच्छा है. This is what is happening
No, no.
in this case.
We
You see,
could
one
we
member
cannot
of a
ex-
joint family.
We
You see,
cannot examine presumption.
No, no, we are not. You see, where is the nucleus? Where is the source of fund? Has anybody
Nucleus
said?
has been proved in
Has
respect of
anybody
Schedule
said?
B.
Has anybody said that the joint family had income from these sources?
Therefore, the evidence.
Where is
Therefore,
the evidence?
So far, appellate
There is
court
no
is
evidence.
appellate court did not.
Need not. You just tell us.
It requires.
We will
Yes.
frame an issue on this, that this particular
Yes.
evidence has been ignored by the court. You tell us
Just
which
see
evidence
what
has
I
been
am
ignored.
saying. That the appellate court, even the trial court has recorded finding. It is the duty of the appellate
No,
court.
no, we will see that. You just tell us
The judgment
which is that clinching evidence on record which has not been discussed by both the courts, which has not been discussed by both the courts.
Therefore, my lord, the evidences are to be seen. That is the
No,
that
evidences
the
are
learned,
to be seen, but second
even
appeal
by
nahi
the
decided.
learned appellate court.
Mr.
In
Sani,
spite
I am
of
repeating it for the last time.
Yes.
You tell us which is that clinching evidence on record to show.
That is our pleading and the
Pleadings-
supported by oral
pleadings-
evidence.
Which,
Now, my lord,
what is
against
oral evidence?
The learned trial
Show
court has-
us which oral evidence has been ignored by both the courts to make the judgments perverse.
It has been recorded in the trial court
बताइए
judgment
कहाँ है
itself.
judgments? नहीं
तो लिखे हैं कि हमने क्या कहा है.
बताइए ना किसका एविडेंस
Yes.
और कौन सा स्टेटमेंट
Yes, your lordship, just see for a
बताइए।
moment.
और कौन सा क्वेश्चन ऑफ लॉ को आप इस एविडेंस में फ्रेम किया?
Your lordship, may kindly see for a moment. This evidence are before the learned courts below.
Let me
The
be
learned-
very, very clear on this, right? Merely because there is a joint family and one of the members of the joint family purchases some property in his name is not sufficient to prove that the property would be a joint family property. Unless two things are proved. One is jointness, that it's a joint family, and secondly, the joint family had a fund. There was a source of income for the joint family as a whole.
Yes.
So this amount was paid, 30,000 was paid in the year 1994. Where is the evidence that what was the source of fund of this particular joint family? Is there any evidence to that effect?
If your lordship may kindly look into the trial discussion by the learned trial court, because the appellate court did not discuss anything with regard to any of the evidences, oral or documentary, except Exhibit 3 by B. Nothing more.
Let us
If
see
I am
which
not
evidence
incorrect-
are you talking
If
about.
I am not incorrect, then your lordship will find the learned appellate court did not take pain to discuss any of the witnesses.
Need not. You just tell us which evidence. Which evidence is clinching on this?
Nobody's evidence except 3 by B, appellate court judgment, if I am not incorrect.
I just want to know from you that which evidence, had it been considered, the result would have been different.
Yes.
This is perversity, right?
This is, yes, perverse.
Yes, now you tell us.
This is correct.
Which
Now
is
we
that
are-
evidence which, had the court discussed,
Only the trial
the result would have been different?
trial court has discussed the PWs.
Yes,
Lordship
where
may
is
kindly
the
see
discussion?
that
Tell
is
us.
not page 20, niche में जो 20 page है. This is the only discussion. PW1 and PW3 have asserted in their evidences that Motilal Bhagat in his old age was quite unable to look after and manage the property belonging to such and such, and Bablu Bhagat was sitting idle, and being the eldest son used to look after and manage the entire mobile and immovable property. At the fag end of his life, Motilal Bhagat was taken seriously, taking advantage of ill health and incapability to look after and manage the property by Motilal Bhagat. Said Bablu Bhagat managed to purchase the landed property described in Schedule C by registered sale deed letter such and such in his own name from the income of joint family fund. Though the sale deed number such and such stands in the name of Bablu Bhagat, but the landed property covered therein was purchased from the joint family fund, and it is all along in peaceful joint possession of Motilal Bhagat, possession of all. Motilal Bhagat died on 16/9/94, leaving behind his wife, such and such, 4 sons, 4 daughters, and who have inherited the property described in Schedule B and C of the plan, and in peaceful joint possession thereof. After death of Motilal Bhagat, there was no good and harmonious relation among the sons of Motilal Bhagat, and in the said family meeting was held on 10/4/11, Dharmendra Dev alias Bablu Bhagat, that the Schedule C land was purchased by him, and he further disclosed that he has already transferred it to 29,520,000 on income, and had no source. Bablu Bhagat had no source of income of his own, as such Schedule C property was purchased from the joint. This is categorical evidence. Whereas Bablu Bhagat is not before the court. No written statement denying such evidence or pleading. Plaint में भी यही categorical रिमार्क. Nothing has deduced from the cross-examination.
Heard the learned
And
counsel
no-
appearing on behalf of the
And this
applicant.
is only one judgment below the Lordship may like to see with regard to the appellate court's duty. Appellate court, lower appellate court, para 7 to 10. It's a very short judgment, 2 pages. Seven to 10. Yeah. As noticed above, the trial court had framed as many as 6 issues. The appeal before the High Court involved questions of law and facts. However, the High Court, without examination of any of these aspects of the safe for medical evidence such and such, dismissed the appeal by cryptic order. The High Court has not adverted to any of the contention of the parties. The Section 96 of the CPC provides for filing an appeal from the decree passed by a court of original jurisdiction, Order 41, Rule 31 CPC provides such and such, A, B, C, D. Thus, the appellate court has the jurisdiction to reverse or affirm the findings. It is settled law that an appeal is a continuation of the original proceeding. The appellate court's jurisdiction involves re-hearing of appeal on question of law as well as fact. The first appeal is valuable right, and all at this stage, all questions of fact and law decided by the trial court are open for reconsideration. The judgment of the appellate court must therefore reflect conscious application of mind and must record the court's findings supported by reasons of its decision in respect of all the issues along with the contentions put forth and pressed by the parties. Needless to say, the first appellate court is required to comply with the requirements of Order 41, Rule 31. CPC, non-observance of these requirements lead to infirmity in the judgment. This is my submission. If your lordship may look to the appellate court judgment, it lacks this thing. This is my submission. Only one paragraph, sweeping observation without referring to any of the witnesses or evidence, either oral or documentary, except Exhibit 3 by B. Nothing more.
It mentions about the oral evidences also.
Nothing. Your lordship just against, your lordship may kindly see. Nobody has been referred, PW1 or
No, need not be mentioning PW1.
That is the law.
But he says
Every
that
issues are to be dealt in spite of the finding recorded by trial court. This is the law laid down by the Lord Supreme Court. Even in respect of a finding, every issues are to be dealt. That is.
then the point of determination फिर क्या ही frame होगा?
तो फ्रेम हुआ तो क्या डिसाइड किए हुजूर? किस रेफरेंस पर किए? हुजूर एक बार अगर गलती से हम बोल दिए तो your lordship just see the appellate court judgment again. Only para 18 is the only paragraph. Nothing more. At page 8. No reference of any of the PWs or even the DWs. Nothing. Only one sweeping line. But the law says that he has to deal with and give his conscious decision. And that is the reason the Honorable Supreme Court held in para 10, para 8 and 9. Except 3 by B, no discussion of anything. Only one sentence. It is final court of fact. Appellate court is the final court of fact in continuation of a suit. It is duty bound to record. He may concur. And section 44 I have already referred. I will not repeat again.
About the learned counsel appearing on behalf of the appellant. Appellant, he has submitted that although there are concurrent findings of facts, the concurrent findings recorded by both the courts
In respect of Schedule C.
in respect of Schedule C property, which was subject matter of appeal before the first appellate court, but the appellate court, while confirming the finding, has not discussed the oral evidence.
Oral or documentary evidence adduced by the plaintiffs.
oral or documentary evidences adduced on behalf of the plaintiff. He has submitted that the entire case in connection with Schedule C property revolved around purchase of property by one of the joint family members, namely
Bablu, Devendu Bhagat, alias Bablu.
namely Dharmendu Dev alias Bablu Bhagat,
Bablu.
Bablu Bhagat, and it was alleged that who was defendant number 3 in the case, and it was alleged that he was managing the properties of the joint family as his father was not keeping well, and he had purchased Schedule C property in his own name by the funds of the joint family. The learned counsel has submitted that.
He did not want.
Sir, please.
Sir.
आपको सुने ना, आप बैठ जाइए.
ठीक है, हम नहीं बोलेंगे.
नहीं, आप बैठ जाइए. प्लीज आप बैठ जाइए. जब तक नहीं पूछे नहीं पीछे लोगे. ऐसे बहुत डिस्टर्बेंस होता है. माय स्टेनोग्राफर कितना दिक्कत होता है.
वेरी सॉरी.
आप बैठ.
आदर से लाचार है.
आप बैठ जाइए. आप एजम्पशन पे क्यों चलते हैं कि आपका केस हम डिसमिस करते हैं? लेकिन क्वेश्चन ऑफ लॉ फ्रेम इस तरह से कर लें कि आगे दिक्कत नहीं हो कि क्या डिसाइड करना, क्योंकि हम तो डेट फिक्स करेंगे डिसाइड करने के लिए. ठीक है ना? जब क्वेश्चन ऑफ लॉ फ्रेम करेंगे उसमें आपको कुछ पूछना हो तो आप क्वेश्चन ऑफ लॉ कौन सा फ्रेम किया उसको देख के बताएं. ठीक है, तब तक हमको लिखाने दीजिए. क्या लिखे लास्ट सेंटेंस?
The learned counsel has submitted that.
The learned counsel has submitted that with respect to other schedule of properties, there has been a decree for partition, and with respect to Schedule C property, there was no such decree, by holding that it was the self-acquired property of defendant number 3. He submits that the defendant number 3 did not join the proceedings and did not even file his written statement. The proceeding was ex parte against defendant number 3 before the trial court as well as before the appellate court. The learned counsel has further submitted that the trial court, while considering the materials, has primarily considered the recitals in the sale deed and has recorded that as per the sale deed, the consideration money was paid by defendant number 3. But did not consider the oral evidence, though mentioned in oral evidence that Dharmendu Dev alias Bablu Bhagat had no source of income of his own to purchase the Schedule C property. The learned counsel has submitted that so far as the appellate court is concerned, although reference has been made to oral evidence led, but there is no discussion with regard to the oral evidence. He submits that the learned appellate court, while upholding the judgment of the trial court has not considered the evidences properly, rather has ignored the vital evidence while coming to such conclusion. He submits that the impugned judgment of appellate court dealing with regard to Schedule C property is perverse and calls for interference. Particularly in light of the fact that the defendant number 3, who is the owner, defendant number 3 never contested the case. Cross examine भी नहीं किया क्या? Appearing. As he never appeared before the court. बताइए कौन सा क्वेश्चन ऑफ लॉ है?
पेज नंबर 9 मेमो का बिल का 4, 5 and 6. क्लब करने से भी एक ही सेंटेंस होता है.
A लिखिए. Whether the learned appellate court whether the findings recorded by learned appellate court in upholding the finding of the learned trial court that the property in Schedule C was purchased from was his self-acquired property and not from joint nucleus of the family. Suffers from perversity on account of non-consideration of oral evidences led by the plaintiff. That should be sufficient.
Yes.
इतना ही काफी है?
The liberty to raise any other issue.
लिबर्टी वर्टी कुछ नहीं. आपको जितना फ्रेम करना है फ्रेम करें. That should be sufficient.
Lordship, otherwise, if lordship may not take it otherwise.
वो तो लिबर्टी रहता ही है हमेशा.
Appeal is to be heard on the following question.
हाँ वो आप फ्रेम करें.
I'm sorry. I'm
The
very sorry.
second appeal is to be heard on following substantial questions of law.
I'm very sorry.
Issue notice to the respondent number 1 to 8. नहीं 1 to 5, 7 and 8 through ordinary process as well as through registered covered with AD. Issue notice to respond number 6 through registered covered with AD. वेस्ट बंगाल का है ना, ऑर्डिनरी प्रोसेस नहीं करेंगे, आएगा ही नहीं सर्विस.
ठीक.
The requisites we file by Monday.
Yes, sir.
Yeah.
1 week at least.
Call for the records from the concerned court. Courts दोनों appellate court and trial court. Post this case, एक और केस कब रखे हैं हम?
23 March.
23 17th of March, नहीं 18th of March 25 in the supplementary cause list, awaiting service.
Online.
Under the heading for final disposal, आने दीजिए सर्विस रिपोर्ट. Appear हो जाएगा तो हम लोग उसको. Let this order be communicated through us.
Online.
Item 23, second bill 53 of 2020.
Yes.
This is defendant second appeal against the judgment of adjournments. The plaintiff filed partition to claiming half share of the suit property. Suit was decreed. Against the preliminary decree lordship, no appeal was filed by the defendant lordship. Against the final decree lordship, appeal was filed, which was dismissed. Against which this second appeal has been filed before the Supreme Court. We can see para 3 of the judgment passed by the learned court.
मैंने ट्रायल कोर्ट का इश्यूज दिखाए.
Try for that. Page 8, internal page 8.
Yes.
If the suit is maintainable, whether the plaintiff has got valid cause of action for the suit, whether there is unity of title and unity of possession in between the parties to the suit with respect to suit property given in the schedule of the plaint, whether the plaintiff is entitled to get half share in the suit property as claimed for, to what relief or relief the plaintiff is entitled to. The findings lordship.
हाफ शेयर दे दिया.
हाँ, हाफ शेयर तो दे दिया.
तो उसके बाद आप
नहीं, फाइनल डिग्री में जो सूट वैल्यू होना चाहिए सूट प्रॉपर्टी का उसको मेंशन नहीं किया, इसीलिए पारा 3 ऑफ द जजमेंट हम दिखाना चाह रहे थे लर्नेड लोअर फर्स्ट अपीलेट कोर्ट. पारा 3 लॉर्ड से पेज 3. अकॉर्डिंग टू अपीलेट फाइनल डिग्री पास बाय द लर्नेड कोर्ट.
एक सेकंड. पारा 3. Yes.
Yes. According to appellant, final decree passed by the land court below is contrary to the law and facts of the case against the weight of the material in the record, and such is liable to be set aside. It is stated in the memo of appeal that report of the pleader commissioner, which is the basis of the final decree, along with the map annexed thereto, are absolutely incorrect, as it is not at all scientific. The pleader commissioner has not taken pain to locate the suit property by taking into consideration the fixed points and fixity, which is primary function and duty of the pleader commissioner is carving out takta for petition of the property. Further, the pleader commissioner has not assessed the value of the property, which is very much important. Lord, say I will refer the judgment of this honorable court, Lord, while making the allotment, which is mandatory, while carving out the takta report of the pleader commissioner performed merely a table work and did not maintain any field work, Lord. Now, Lord, say I am the relying the judgment passed by this honorable court relating to
finding क्या है?
Findings. Para 10.
पढ़िए.
On perusal, the case reported in so and so case that cases were related to encroachment of land, and in that case, the Honorable Calcutta High Court and
नहीं ये सब ये फाइंडिंग नहीं.
आगे बढ़ जाते हैं. Para 11.
एक से
para 12
नहीं para 10 के ऊपर the instant case is of a different footing. The pleader commissioner has not allotted share to the parties in the available land for partition.
appellate court का
हाँ हाँ appellate court का
On
पेज नंबर
detail of the
14
law
पेज नंबर 14 टॉप से पढ़िए
हमारे में
इंटरनल पेज 14 टॉप में पेज नंबर लिखा हुआ appellate court का
जी
इंटरनल पेज 14
इंटरनल पेज 14
ठीक है
जी
उसका टॉप से पढ़िए the instant cases of
the
different
instant case of the different footing the pleader commission has allotted the share to the parties in available land for partition. Here there is no any dispute regarding identification and boundary of the suit land. Thus I am view that these cases law do not help the appellant as well as there is no need of taking fixed point to locate the suit property. The pleader allotted the share to the parties to the suit proceeding.
Suit was already identified.
Identified.
The boundary was already
But
there.
the value has not been mentioned.
Need not be. Value का क्या है जरूरत?
Lots of mechanism judgment passed by this honorable court. Lots mechanism para 7 आपके पास para 7 lots. Thus, the holding that lower appellate court has committed a substantial error of law since it has gone against the fundamental principle of passing a final decree in a suit for partition. I allow the second appeal set aside the impugned judgment and decree of the court will remanded the suit to the trial court for passing a fresh final decree. In terms of preliminary, the trial court will direct the Amin Commissioner to value the entire property, ensure allotment the property to a different share equal in value in terms of preliminary decree.
यही ना आप बताइए preliminary decree में was there any direction to allocate in terms of the value or it was the decree was in connection with area of property?
It has not been mentioned the value.
नहीं आप preliminary decree दिखाइए कैसे देखिए just a moment if there is a property and the partition is to be done in terms of the value of the property then valuation is absolutely necessary. But if there is a property which is identified, which has to be divided into 4 equal shares, right? There is no need of any valuation. बताइए कहाँ है आपका preliminary?
वो तो preliminary decree में तो नहीं लिखा हुआ है.
नहीं लिखा हुआ है ना? That is sufficient. Not necessary.
Value नहीं लिखा.
You see, when there has to be a partition by meets and bounds, and the valuation of the and the direction is to give equal share.
Equal share.
Right? In terms of area.
In terms of area.
If there is a direction to give equal share in terms of area, there is no need of any valuation. Not required.
This is my point.
That is all.
कुछ है नहीं तो क्या?
ऐसा सीधा खड़ा होकर बोलना चाहिए ना कुछ नहीं है.
नहीं बोलेंगे तो फिर लोग देखते हैं मीटिंग में.
ये भी एक प्रॉब्लम. अच्छी बात है. लोगों को देखना चाहिए. बिना सुने ऑर्डर नहीं किया.
हाँ बिना सुने ऑर्डर नहीं.
मिस्टर सानी को इतना देर सुन लिए तो कंफ्यूज हो गए कि क्या होने वाला है. देखिए मिस्टर सानी these second appeals are very serious matters. है ना घर द्वार का बात होता है generations to generations की बात है. हम तो आपके साथ साथ पढ़ रहे हैं लॉ भी पढ़ रहे हैं फैक्ट भी पढ़ रहे हैं. क्योंकि घर ऐसी चीज है ना कि कोई बेघर हो जाए तो पूरा जनरेशन उजड़ जाता है.
लेकिन बीच में कुछ साल
नहीं था.
छूट गया. अब धीरे-धीरे आदत पड़ जाएगा. बहुत सुंदर ढंग से
वो हम एक जजमेंट पढ़े थे उस पर. वो तो आ जाएगा तो हम डिसाइड कर देंगे. आप जजमेंट नहीं लेके आए कि फैमिली जॉइंट फैमिली का फंड में किस तरह से उसको एडजुडिकेट क्या कंडीशंस होता है एडजुडिकेशन का. आराम से आप यहाँ इस कोर्ट में आराम से सब कोर्ट से निपट गए. क्योंकि अब इतना सुन लिए ना तो अब टाइम नहीं लगेगा डिसाइड करने में. नेक्स्ट डे आप तैयार हो के आए.
बहुत जरूरी है. कंसंट्रेशन रहना से ही उसको हम सैटिस्फाई कर सकते हैं.
जो तो बहुत सेकंड अपील किए 2018-19 में.
बहुत
किए सेकंड अपील. हम लोग तो बहुत किए.
नहीं अच्छा है हमको तो बहुत पसंद है. सिविल आई रियली लाइक. हाँ लिखिए. Second appeal number 53 of 2020. Heard the learned counsel appearing on behalf of the appellant. The learned counsel for the appellant has submitted that the matter arises out of partition suit number 92 of 2005, wherein the plaintiff had claimed half share of the suit property. He submits that altogether 5 issues were framed and the suit was decreed and preliminary decree was prepared. Pleader commissioner was appointed and thereafter final decree was also prepared. The learned counsel has submitted that the appeal was filed by the defendants, by the defendants, and the main ground in the appeal was that
para 3 में submission है.
yes, the main ground in the appeal was that the final decree passed by the learned trial court was contrary to law and the materials on record. And the pleader commissioner had not taken the pains to locate the suit property by taking into consideration the fixed points and fixits, which was a primary function and duty of the pleader commissioner in carving out takhta for partition of the property, and that the pleader commissioner had not assessed the value of the property while making allotment, which was mandatory. It was argued that the report of the pleader commissioner was perfunctory and merely a table. The learned counsel has submitted that the appellate court dismissed the appeal and the appellate court's judgment calls for interference as admittedly no valuation of the property was done. He has further referred to the judgment passed by this court reported in 2004 within bracket 4 bracket close JLGR 452. Amit Rao versus Kanhai Rao, and has submitted that this court has held that this court ultimately remanded, in the same case, remanded the matter to the trial court for passing fresh decree by directing the commissioner to value the properties and ensure allotment of properties. After hearing the learned counsel appearing on behalf of the appellant, this court finds that the title suit was filed by the plaintiff seeking a preliminary decree for partition of half share of the suit property, and on appointment of pleader commissioner, half share be carved out in favor of the plaintiff from the suit property and his takhta be separated. The trial court framed altogether 5 issues as under. The suit property was the suit was decreed and it was held that the plaintiff was entitled to half share of the suit property. And a preliminary decree was directed to be prepared. By the order dated 6/12/2018, the order dated 6/12/2018 passed in partition suit number 92 of 2005 has been placed on record, which reveals that Advocate Commissioner had submitted his report on 22/2/2018, and it appeared from the report that the measurement and inspection of the suit property was done after giving notice to all the parties, and the son of the defendant was present at the time of measurement of land. With the help of executive magistrate and armed police force, separate allocation of share of plaintiff over the property along with boundary was done as per the preliminary decree dated 29/2016, and also a sketch map was prepared showing allotment. And after final report, no objection was filed, and ultimately the report was accepted for carving separate share of parties as preliminary decree, and the final decree was ultimately prepared. Before the appellate court, the appeal was filed by the defendants against the final order dated 6/12/2018 passed in final decree proceeding in the original suit, by which the learned Munsif had accepted the report of the Advocate Commissioner and the appellant and the defendant appellant prayed for setting aside the final decree passed in the partition suit. the points raised by the appellant have been recorded in paragraph 3 of the impugned judgment. And upon perusal of paragraph 10, the appellate court has recorded that the pleader commissioner has allotted share to the parties in the available land for partition. There was no dispute regarding identification and boundary of the suit land. And therefore, there was no need to take fixed point to locate the suit premises. The pleader commissioner had allotted share to the parties to the suit in available identified suit property. The learned appellate court referred to the provision of Order 26/14 of CPC dealing with the procedure of commissioner. The learned appellate court further recorded that the learned trial court did not commit any error in accepting the report of the pleader commissioner, which was in accordance with the law and procedure. The appellant had full knowledge of the original partition suit from beginning. He was examined as DW1 in the suit. The appellant had also appeared in the final degree proceeding but did not file any objection against the report of the pleader commissioner. And ultimately dismissed the appeal. This court is of the considered view that so far as the judgment cited by the petitioner is concerned, the appellant is concerned, the state judgment was dealing with valuation of share and the final decree was prepared without its valuation. And consequently, this court had interfered with the final decree and had remanded the matter to the trial for necessary valuation and preparation. This court finds that the state judgment does not apply to the facts and circumstances of this case. Here the suit property was duly identified and the final decree was also prepared in favor of the defendant, who was the appellant before the first appellate court. In the aforesaid facts and circumstances, this court is of the view that no substantial question of law arises for consideration in this appeal, which is hereby dismissed.
Item 24, second appeal 56 of 2020.
I am from this one. इसको एक एडजॉर्नमेंट दे दिया जाए तो फाइल के साथ नहीं आता, इसको या तो खोज लेते हैं नहीं तो फिर कंस्ट्रक्ट।
Prayer for time is allowed by way of last chance. Already हो चुका है 9/9/24.
वो हुआ था डिफेक्ट
नहीं, ऐसा नहीं दिखाइए।
खोल देते हो, तैयार करो।
क्या मैटर, क्या मैटर?
मैटर है कि फील्ड इट का बहुत आदमी, इनफैक्ट ठीक आदमी।
सॉरी, आज ब्रीफ नहीं है आपके पास, कल ले आइए ब्रीफ।
कल नहीं आ पाएगा, देख लेते हैं।
तो कॉस्ट से के साथ एडजर्न करेंगे क्योंकि लास्ट चांस ऑलरेडी हो ही चुका है। कॉस्ट देखकर आपको बताइए कितना टाइम चाहिए, जितना 1000 कॉस्ट करेंगे उतना दिन का एडजर्नमेंट।
तो उससे अच्छा डिसमिस फॉर डिफॉल्ट कर देंगे।
नहीं करेंगे ना, लिखेंगे कि आप बहस नहीं करना
जो हो, लेकिन अब वो जो कोई कंडीशन हमसे नहीं फुलफिल हो पाएगा क्योंकि हम फाइल खोजवा रहे हैं।
खुलवा रहे हैं फाइल,
और नहीं तो हम फिर कंस्ट्रक्ट करेंगे फाइल, सप्लीमेंट्री अप्लाई करेंगे। ये खुलते दिन लग जाएगा, ये दिमाग में नहीं था उसे।
यही फाइल है ना आपका?
जी,
यही तो फाइल खुलवा रहे हैं आप। इसका तो सॉफ्ट कॉपी आपको दे देते हैं, इसका करना ही क्या,
दे दिया,
दे देते कॉस्ट के साथ देंगे। लास्ट चांस ऑलरेडी हो चुका है, कॉस्ट के साथ एडजस्ट करेंगे। नहीं करिएगा तो कोई बात, रेस्टोर भी नहीं करेंगे, रेस्टोर और डबल कॉस्ट के साथ करेंगे। देखिए गलत सबमिशन मत किया करिए मेरे सामने, हमको बिल्कुल पसंद नहीं।
हम गलत नहीं करते।
आप कैसे बोले कि डिफेक्ट पे लास्ट चांस हुआ था?
उनको दिमाग में नहीं रहा, ये बात तो स्पष्ट है। लेकिन ये छोटा चीज के लिए झूठ बोलेगा वकील, ऐसा नहीं होता।
नहीं, छोटा चीज ले,
छोटा चीज ये वो जो एक बात ये है कि लास्ट चांस में हम इसको दिए थे टाइप कॉपी देने के लिए सेक्शन में।
आपका इतना कथा कहानी जो है ना, दूसरा
उसके बाद फाइल नहीं मिल पा रहा है। उस बार भी मैं यही कर,
बहुत अच्छी बात,
खोजवा रहे हैं, फाइल को मिल
तो
जाएगा।
मतलब उस समय से खोजवा रहे हैं, सितंबर से, अभी तक नहीं मिल पाया।
हाँ मिल जाएगा, लेकिन अभी क्या पता कि आज ही लग जाता, ये नहीं था दिमाग।
कोई बात नहीं, रोज लिस्ट करेंगे एवरीडे, जब तक आपको फाइल मिल ना जाए। देखिए सेकेंड अपील नंबर 56 ऑफ 2020।
Last week,
Counsel for the
एक chance
petitioner,
दे
just a moment. Counsel for the appellant submits that he has lost his file and he is trying to trace out the file. Post this case tomorrow. रोज लिस्ट करेंगे एवरी डे, और जिस दिन मन होगा उस दिन डिस्कस करेंगे। खुद ये फाइल, सेकेंड अपील का फाइल गुमना का मतलब समझ रहे हैं? आपके पास ओरिजिनल डॉक्यूमेंट्स भी बहुत सारा हो,
ओरिजिनल नहीं है
तो खोज के निकाल
जो सर्टिफाइड था।
हाँ,
एक सप्ताह दे दिया जरूर
नहीं, आप कल आइए, कुछ नहीं। सेकेंड अपील का फाइल खोजने घूमने का बहुत सीरियस मतलब होता है।
खुजवा रहे हैं।
आज तक भी हम अपना ऑफिस में सेकेंड अपील का कुछ फाइल रखे हुए हैं, आदमी नहीं आता लेने के लिए, उसका लिस्ट बना के बाकायदा तिजोरी में रखे हुए। ठीक है, सेकेंड अपील का फाइल
एक सप्ताह दे दिए,
एक हफ्ता नहीं, आप कल आइए, रोज खोजवाइए फाइल।
नहीं खोजवा
तो मुंशी जी को बोलिए खोजिए।
मुंशी आज रहता तो आज बाहर गया हुआ है,
आ जाएगा।
Item 25, second appeal 58 of 2020.
This is the plaintiff's second appeal. It is a concurrent finding of facts so far as the plaintiff is concerned against it. The plaintiff filed the suit seeking a relief with respect to his possession and title over the land in question. The plaintiff came in possession of the land by virtue of a settlement made by the government in the year 1984, 30th March 1984. This land, which is the suit land, this was acquired by the state in terms of the Bihar Land Reforms Fixation of Surplus Area Acquisition Act 1961. However, subsequently and after that acquisition by the government in accordance with that 1961 statute, this land was settled with this plaintiff and also other persons who were found entitled to be settled with such land which was vested with the state. Subsequently, the original landowners, the recorded tenants, the contesting defendants, they challenged the action of the state government of acquiring the land. They could succeed in that proceeding, and the acquisition of their land was declared to be illegal. But that was much after the settlement of the land in question. The only thing which will arise for consideration before this honorable court in this appeal is that the plaintiffs, they are neither the trespassers, they are not the illegal occupants or the unauthorized. They by virtue of that settlement made by the government, which has a sanctity of law, they came in possession of the land in question. However, the action of the state government in acquiring that land as surplus land, that was found to be illegal, and that was set aside, and all consequential.
So it's the government who allotted the land.
Yes, yes.
And the acquisition by the government was held to be illegal.
Yes.
So therefore you have no title.
Now, so far as the plaintiffs are concerned, since they by virtue
Adverse
of the
possession तो नहीं होगा ना.
by virtue of that is one of our
Adverse
issue.
possession का issue भी नहीं frame होगा.
We have raised this issue that since we came there and it was the possession was hostile to the knowledge of the actual landowner.
ऐसे कैसे होगा? You see, government had acquired the property and the government had allotted it, but the acquisition was held to be illegal.
Yes.
So the right will flow back to the original owner.
That thing is there, that I cannot dispute. But the thing is that now his possession on basis of a settlement done by the government, that was also.
आप government से compensation claim करिए जो मर्जी करिए, लेकिन आपका title तो नहीं होगा ना. Because the very basis on the it is something like vendor का title ही खत्म हो गया. अगर vendor can pass a title, government can pass a title, whatever it has. If that title, that source is gone, it goes.
But at that point of time when the settlement was
That's
made,
right.
that was very much within the.
That's right. We appreciate that. Okay.
And on the issue of possession, since they came in possession since 1984, and therefore I submitted that it was not a unauthorized possession or nor as illegal possession as a trespasser. That was a possession duly authorized by law.
We'll take care. Second appeal number 58 of 2020. Heard the learned counsel appearing on behalf of the appellant. The learned counsel for the appellant has submitted that though there are concurrent findings recorded by both the courts by dismissing the suit, but the learned courts have failed to consider that the plaintiffs एक है कितने हैं?
Plaintiffs no, multiple plaintiffs.
Plaintiffs came in possession of the property by virtue of allotment made by the government, which the government acquired by virtue of the provisions of Bihar Land Reforms. पूरा नाम क्या है एक्ट का?
Bihar Land Reforms, fixation of ceiling area.
Fixation of ceiling area.
And acquisition of surplus land.
And acquisition of surplus land.
It is within bracket. Act 1961.
Act 1961. He submits that the appellants remained in possession of the property, but the acquisition of land by the government was held to be illegal. The learned counsel has further submitted that the learned courts have failed to consider the long possession of the appellants over the suit property, and that the allotment of land, allocation of land to the appellant by the government was itself in accordance with the law.
And there was a parcha was also granted after
And
that
parcha was also granted
in favor of these
in
applicants.
favor of these appellants, and the right stood crystallized in favor of the appellants. After hearing the learned counsel appearing on behalf of the appellants, this court finds that the title suit number 27 of 2000 was filed by altogether 5 plaintiffs seeking a declaration of adverse peaceful possession of 14 years on the suit land and its confirmation of their right title interest for suit property in Schedule A claimed to have been perfected through adverse possession, delivery of adverse possession and delivery of possession to each plaintiffs may be carried out separately by a mean according to their peaceful possession. The specific place of the plaintiffs was that the property involved in this case was allotted to them to the extent of 5 acres each by the state of Bihar on 30/3/1984. And the defendant number 1 to 3, who was the state, obtained the land under Section 27 of the aforesaid Act due to surplus land of recorded tenant. And they were in peaceful cultivating possession of the land till the date of settlement. It was their further case that the measurement was also done. The measurement receipts were also issued in their name. And their adverse possession was admitted by the state. The defendant number 5 to 9 were made pro forma second party, and as per the plaintiffs, they had lost right title, possession and interest over the disputed land, as it was already taken over by the state government. The cause of action arose on 18/11/97 when all pro forma defendants raised objection not to cultivate the disputed land. it was also their case that pro forma defendants had also lodged that the plaintiffs that the pro forma defendants they filed FIR.
Yes.
Pro forma defendants had also filed FIR on 18/11/1997 in Godda title PS case number. In Godda title PS, and they admitted that the plaintiffs were cultivating the land and it was in their possession. The defendant number 1 to 3 had appeared and took a specific stand that the settlement patta was granted on 30/3/1984 in favor of the plaintiffs, and in writ petition and it was challenged in writ petition being CWJC number 1753 of 1984, which was initially dismissed for default was ultimately restored. And finally disposed of, and the order dated 18/2/1981 of acquisition of suit land by government under the provisions of BLR Act was cancelled by the learned subdivisional officer Godda by letter dated 19/6/1997. The defendants also filed their written statement and had pleaded that no legal right vested in favor of the plaintiffs and the suit was not maintainable in view of the order passed by Honorable Patna High Court dated 8/10/1996, passed in CWJC number 1753 of 1980. They also pleaded misjoinder of necessary parties. The learned trial court framed as many as 8 issues, which are as follows. Page 46, internal page 7 of the trial court judgment. And decided issue number 3, 4, 5 and 8 together in paragraph 7 and held as follows. इसको quote कर देंगे. Yes, हम mark कर देंगे. The other issues were also decided together, being issue number 1, 2, 6 and 7, and ultimately against the appellant, and ultimately the suit was dismissed. So far as the first appellate court is concerned, point of determination कहाँ है?
point of determination, the appellate court has in fact not properly formulated the point of determination.
But the appellate court
Para 10
considered all the issues
Ha.
framed by the learned
Yes.
trial court.
Though not
And
specifically formulated
yes,
the point of
that's
determination.
right. Considered all the issues, सारे issues को
हाँ,
considered.
para 10 is the finding.
Yes.
Para 10,
And-
internal page 10.
And recorded concurrent findings. And was of the view that the learned trial court rightly held that the plaintiffs were not in peaceful, continuous, uninterrupted possession of the suit lot, and that they had not perfected right title interest over the suit land by way of adverse possession. इसका कुछ findings हम quote कर देंगे, है ना? This court finds that both the courts have given concurrent findings that the appellants did not perfect their title through adverse possession, and by considering the materials on record, the learned counsel for the appellant would not point out any perversity in the impugned judgments. This court finds that there is no substantial question of law involved in this appeal, which is hereby dismissed.
One perversity may be recorded in our submission.
ऐसा नहीं, आपका submission हम record करके
Exhibit 3 and 4
नहीं
का
नहीं,
non-consideration
अब
is
order
the
होने के बाद submission मत किया।
Next case was
हाँ, क्या?
one accommodation.
क्या
I
हुआ?
could
Next.
not, next case, I have not read.
Item 26.
Confess not. I could not read. एक ही केस में 1.5 घंटा लग गया मतलब और जो नेक्स्ट वीक में क्या आफ्टर वीक
Specific relief का केस है।
हाँ जी
अभी बहुत सारा जजमेंट।
स्पेसिफिक रिलीफ का केस नहीं
Specific relief का केस है ना?
डिक्लेयर हम पढ़े नहीं हम आई एम वेरी सॉरी मैम
ठीक है, कल करते हैं।
कल नहीं चाहिए नेक्स्ट वीक में कोई डेट रखें so that I can properly assess.
Second appeal number 81 of 2021. Pose this case at the appellant present, at the request of the appellant, pose this case in the supplementary list on Tuesday.
Correct.